Good,
Yes, we're ready. Thank you. Thanks for the time.
good morning. Good morning. Good morning. Today we will continue to hear from Mr. Argiri Alisandratos, who appears on behalf of the Department of Families, Fairness and Housing. This is the second day of the hearings in Hearing Block 5, where we are primarily hearing from government witnesses on the priority areas of child protection and criminal justice. Before we start today, I would like to invite Commissioner Hunter to give the welcome to country and acknowledgement of country.
Thank you, Chair. So I'd like to acknowledge we are on my ancestral lands, the lands of the Wurundjeri, and pay my respects to elders past, present, all those that have gone before us, so we're able to give voice to us and we're able to sit in positions like this. And being on topic, I'd like to acknowledge stolen generations, those that didn't make it home, those that did, and those that are still searching. I'd also like to acknowledge those families lost within the child protection system today and honour those families and those children and hope that they too make it home safely with strong cultural connections. So Woman Jekka, come with purpose. Thank you.
Thank you, Commissioner Hunter. Council, may I have appearances, please?
Thank you, Commissioners. I appear with Ms Buxton to assist.
Thank you, Commissioners. I appear for the State of Victoria with Mr Chris Horan and Ms Caparella and Ms Hilly.
Commissioners, we acknowledge the Wurundjeri people. We acknowledge that we're on the land of the Wurundjeri people of the Kulin Nation. I offer my respects to elders and ancestors. I recognise the strength and the love of Aboriginal people for their families and this difficult task we are facing yesterday and today and throughout this hearing block in dealing with the issues of child protection, the impact this has on Aboriginal people and the impact this has on those following this commission. Commission pleases.
Thank you, Council.
Thank you, Chair, and thank you, Commissioner Hunter. We would also, on behalf of the state, like to acknowledge the traditional owners of the land on which we meet today, the Wurundjeri peoples of the Kulin Nation, and pay our respects to their elders, past, present and future. We further acknowledge all First Nations people and traditional owners here today, as well as all First Peoples who have participated in this important inquiry. The state acknowledges in particular the importance of the topics being considered today and yesterday. The state acknowledges its role, its shameful role in the treatment of Aboriginal people and their children.
Thank you. Thank you. When we acknowledge country and ancestors, past and present, and emerging, the emerging means the people we're talking about now are young people and the babies. So thank you for noting that. Council, thank you.
Commission pleases, we resume the evidence today of Mr Alisandratos.
Thank you.
Mr Alisandratos, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
I do.
Can I finish the discussion we were having yesterday and your evidence in relation to the operation of the Act, the primary Act? Yesterday I was asking you questions about the best interests of the child and additional considerations required by subsection 10. And if we could bring up on the screen section 11, which appears at page 42 of the Act. Just before, while that's being brought up, the best interest considerations and the principles set out in section 10 are relevant considerations mandated for all decision makers in the system, are they not?
They are. Can I, just before I continue, can I also begin by acknowledging traditional owners of the land that we're all meeting on today, pay my respects to elders past, present and members of the Wurundjeri people, and also acknowledge traditional owners throughout Victoria and those that are with us today. Thank you, Commissioner Hunter, for your welcome. Yes, given the difficult circumstances that we're talking about today and the shameful history, I'm here again today to make a significant contribution to your work, Commissioner. So thank you for the opportunity.
Thank you.
Thank you. So all decision makers, that is the department, Aboriginal controlled organisations, community service organisations and judicial officers in exercising the jurisdiction under these acts, must adhere to and comply with the best interest principles and the matters raised in terms of the interpretation of those best interest principles. Is that correct?
That's correct.
Okay. They must also give consideration to two additional matters: the decision-making principles set out under Section 11. That's the first thing, correct? Yes. And the additional decision-making principles for First Nations children set out in Section 12.
Yes.
So just starting with Section 11, in making a decision or taking action, the Secretary or a community service must also give consideration to the following principles. First, A, the child's parent should be assisted and supported in reaching decisions and taking actions to promote the child's safety and well-being. So my first question is a general one about this provision in application. How well is the department meeting this principle in your view?
As I think I talked about yesterday, whenever child protection intervenes in the life of children and their families because of a report of concern, and through the process of assessment and investigation, the first order of priority is to provide any possible support to families so that families can be preserved and children can be enabled to remain within the family setting in the safest possible way. So in that regard, there are a whole range of supports that are developed and provided with assistance to the family to maintain and promote the child's safety and wellbeing within the family construct. So my question was, how well is the department meeting the principle? Could there be room for improvement in the application of this principle? I think the principle is embedded deeply into the practice of child protection practitioners, and when they're determining the needs of a particular child and family, is there room for improvement? There is always room for improvement in terms of how that principle is applied. But when you think about and look at the data in terms of how many children end up being removed from the point of report all the way through to removal, and it being notwithstanding the number of First Peoples children we have in care, but relative to how many reports and investigations we undertake, it would suggest that we are preferencing that principle quite significantly in terms of maintaining children within their families.
So when you say there's room for improvement, bearing in mind that this Commission is looking for ways to make recommendations that improve the system for First Nations children, where can you point the Commissioners to those areas of room for improvement?
I think probably in the realms of how we strengthen provisions and guidance to practitioners to reinforce the need that ultimately parents and families are the binding unit that we are seeking to protect. and that's already in the legislation. It is quite profoundly built into our practice, but anything that we can do that brings a more significant cultural perspective to it, I think would be a useful way of continuing to maintain the focus and potentially improving our practice around it.
So is that just a matter of reviewing the documents, or is that a matter of embedding training?
I think it can be all of those things. It could be how do we translate that principle within the frameworks, the risk assessment frameworks, our operating frameworks. How do we reflect it in training of our practitioners, and reviewing that and ensuring that we have that principle adequately embedded within every element of our practice.
And what would need to happen to make that, to embed those principles in practice? And just, I'd appreciate your thinking at this point about, could we do a policy review, for example, to ensure that the policies reflect those principles throughout each of the hierarchy of documents that guide a child protection practitioner's practice? Is it a matter of red flags and templates that provide checklists? Is it a matter, and I'm talking off the cuff here, is it a matter of training and ensuring that the training is sufficient and adequate and provided by appropriate people with themselves embedded cultural knowledge? I'm looking for examples.
Look, I think all of those areas are possible. I don't want to suggest that those things are not being done at the moment, but in terms of how we look to assure ourselves, even beyond what we've done to date, to ensure that they are deep, that the principles such as these are deeply embedded in our practice, would be useful considerations for the Commission in terms of further review, further assurance that the department could bring to these matters.
So does the department have a regular audit and assurance process for checking on
we have
principles?
What I would say is that it's a very dynamic process. Our Office of Professional Practice, its sole purpose, if you like, is around how we bring the practice dimensions and ensure that our workforce have the most up-to-date guidance, systems and capacity to be able to undertake the functions of statutory protective interveners. And that is a dynamic process. We look at research, we look at the evidence that is emerging, and equally we draw that evidence from our First Peoples organisations and communities who are so pivotal to driving some of the changes that we've been navigating over the last decade or so. So you could see some of that already reflected in our processes, in our guidance to practitioners, and I would say that we will continue to do more of that as more evidence emerges, as more models are put in place through our engagement with our First Peoples organisations.
So 4 aspects of matters that arise from what you've just said that I want to touch on. The first is culture and the development of cultural safety plans. So how are you tracking in terms of the application of this principle and the development of cultural safety plans?
I think on cultural safety plans, I think we still have a way to go, is probably what I'd say. I think there is a significant effort and improvement that has occurred over the last few years. We've invested more in cultural safety. We've got more cultural safety practitioners and advisors across the department and our Aboriginal community controlled organisations. We certainly have lifted our compliance with our Aboriginal cultural planning to about mid-60% of children having a cultural support plan. But as you can see, there is room for some significant continuing improvement for us to make in relation to cultural planning.
Sorry to interrupt, do I understand what you're saying is that only 60%
About 66%.
children have that plan, and the requirement or the policy is for 100%?
100%, that's right.
And why is there a gap? What's the lack of capacity there?
There are a range of factors that contribute to that gap. One of the factors is engaging with families, understanding family history, genealogy, being able to develop the appropriate cultural plans that are relevant for that individual child within the context of their family and their cultural background. There are workforce challenges in terms of just ensuring that we've got enough advisors who are providing that support to child protection. There are some challenges around how care teams come together to bring all of that intelligence together to formulate a cultural support plan. So there's a range of barriers that we are working to overcome.
Is it the 100 aspirational or mandatory?
It's a mandatory requirement.
And you're saying that we're at
66%.
It's mandatory.
Yes,
That's a concern.
it is.
I can see Commissioner Hunter wants to ask some questions there, but can I ask first, the genealogy work that you mentioned, do you commission research about that?
We fund the Victorian Aboriginal Childcare Agency to provide that service for our practitioners.
And so does it rest with them, or is there more investment needed to map the entire state?
I think there's always room for more capacity and more scale to be brought to these things, yes.
Okay. In terms of the investment in the workforce, you're talking about investment in First Peoples being within the workforce directly?
Yes, that's right.
And in terms of information sharing, you're talking about enabling that workforce to participate in the sharing of information in a way that assists them to get to meetings, basically, and share information. Is that support for those meetings?
Sorry, I don't.
Yeah, you mentioned the sharing of information
Through care teams.
Yes, care teams. Sorry.
Yes. No, that's okay.
Yeah, and what is the problem with them getting together and sharing information?
Well, it's the inevitable challenge of many of our practitioners, both in child protection and across our community service and Aboriginal community-controlled organisations, trying to manage many demands and trying to get the right time dedicated to these important elements. There are always competing elements, so it's a demand pressure.
Yeah, I'm just going to say first off, 66 is not acceptable. You spoke yesterday about how it's a protective factor. Culture's in your words, and I'll paraphrase that, culture is a protective factor for our children and our families.
Yep.
Yet they're in a system that harms them. So wouldn't that be your first thing, to make sure they're protected?
Absolutely. So there are probably a number of elements to that. Our priority is to protect children. Our priority is to protect children within the context of their family, community and culture. And cultural support plans are absolutely critical to that. So you're absolutely right about saying, you know, the fact that we haven't got to where we need to be, that is 100% of children having a live, valid cultural support plan, is clearly not good enough.
No, it's not good enough, and we've got time left, so we'll follow up those numbers, and we seriously hope they rise.
It's interesting that we're asking the families to jump through all these hoops in order to get their children back ultimately, but then when the department doesn't do their job, it's okay. You just said it was mandatory 100%, and yet
Is
60s.
It is.
Sorry, is the number 60 or 66?
it's 66%.
66, sorry, just to clarify. Either way, 66.
Yeah,
That's terrible.
It's certainly not where we need to be. That
Well, it's clearly not. Not certainly. It's not where the department needs to be.
and again, there has been significant investment in more capacity, more funded capacity through our Aboriginal community-controlled organisations, because they are critical to assisting the development of cultural support plans, and obviously each and every one of those cultural support plans need to be signed off and approved by a local chief executive officer of an Aboriginal community-controlled organisation.
Can I, who writes the actual plan? Just so we're clear on
Yeah,
the process.
it's a joint responsibility between a child protection practitioner and the cultural support advisor from an Aboriginal community-controlled organisation, with input from many others around the care team, including carers themselves and family.
I think some of it comes back to what we were talking yesterday about authority, and that there is no one place that we can pin these on. And I've heard yesterday and already today, you talk about improvement. You know, what changes need to be made specifically for culture support plans, the improvements, because I don't want to hear we know there's need for improvement. What are you doing? These kids will be lost to their families, to their culture, and if we have not learned anything yet about the Bringing Them Home report, I seriously recommend that the department all go and read that report, because this is not good enough. 66, it's ridiculous. How many kids on cultural support plans have no contact with their family? How many kids on cultural support plans are living off their cultural lands? How many have no idea which mobs they belong to? Like, these are the questions. You're the parent. You're the parent here. We have an obligation to our kids to make sure they know who they are, they're brought up correctly, they're doing everything. Who holds you accountable? Who holds the department accountable? Because unless you're in there working on the coalface every day and see these children and these parents' tears, and this probably out of frustration more than anything, but we didn't ask you here not to answer our questions and to shuffle around. The improvements, we want to know what these improvements are. This, what we're talking about, is nothing new. We're talking similar things to the Bringing Them Home report. It is not good enough. It's just not. So, thank you, Mr. McLeod.
In terms of those cultural plans, is there any sort of quality assurance tool or mechanism that is applied to the development of those plans by the department?
Well, the biggest quality assurance is the signing off of those cultural support plans by a chief executive officer of an Aboriginal community-controlled organisation local to that child's community.
Okay.
That is ultimately that is a process. It's not the department. Yes, the department absolutely has a role to play in driving and implementing those cultural support plans and developing them, but it's done with the assistance of those who've got cultural knowledge, and it would be it would not be accurate for us in the department to do that in isolation without First People's significant input into those cultural plans.
You're not blaming Indigenous families, are you? No.
No, not at all.
Is there a gap? Sorry, Commissioner Bell. Is there a gap of time between that's not being signed off on from say getting it done on the ground to getting up to the CEO of an Aboriginal organisation?
I think what I would say, Commissioner Hunter, is that the process of developing a cultural plan, by the very nature of the complexity of getting the right inputs, takes time. The engagement with all the family members, the engagement with the wider community, and that engagement is through our cultural support advisors who are funded in our Aboriginal community controlled organisations. They lead much of that work, as they should, because they are the cultural experts. And that takes some time to get that engagement.
What's the average time? What would be, say, the average time from a child?
The requirement is to have a cultural support plan in place within 19 weeks of a child coming into care.
And is that being achieved?
No, I think I haven't got.
But a no?
No. Okay. I haven't got the numbers in front of me, but it's my understanding that it's taking longer for a number of those cultural support plans to be developed, and these are things that we're working through. There are barriers along the process, all the way from the development phase to the endorsement and sign-off phase, and there are also some barriers around identification of children's Aboriginality as well. That means that it takes a longer process and a longer time to work through some of those issues, and there are tension points in some of that, particularly where it is not. There are different views about the genealogy of some Aboriginal children.
And who does that sit with? Sorry, Ms McLeod, to go off the line. Who does the identification sit with? It sits with the department, because we accept self-identification clearly as the only requirement that we have. But at times, that may conflict with the local community's understanding about the history of some children and their families, and that takes some time to work through. So these matters can be complex. There are some organisations that require proof of identification. This remains an unresolved issue in terms of how we arrive to an agreed approach for resolving identification. How long's the Aboriginal Children's Forum been going?
Since 2015.
And it's never been on the agenda?
It has been on the agenda, and there has been a position put, but it is not resolved at this point.
I'd suggest get resolved, because that's a big issue for our mob.
How many out of the 34% that haven't been done, you said 66 are, having the complexity around identity?
I don't have that information in front of me.
I'm
not suggesting it. I'm not suggesting it's a big proportion. It is a smaller proportion, but it is one element that requires a significant working through.
I come back to, it's mandatory.
Yes, it is.
It's mandatory that these are done, and
Yes, it is.
I wonder how much weight are these really given in the grand scale of our kids coming into contact with the system. Doesn't sound like 34 is a lot.
It is. It is. And just on the weighting, I think both from a policy and practice perspective, cultural support plans are seen as critical. They are fundamental to how we maintain connection to community and culture for children that are placed in alternative care settings.
That's true. Why are 34% of cases not done? I don't understand that.
Oh.
And can I say I don't, with respect to your evidence generally, and with great respect to you, I have a lot of difficulty squaring up language like room for improvement, or this thing is critical or that thing is critical, with your concession that the system operates shamefully with respect to Aboriginal children taken into care. And if the system operates shamefully, then surely the system is shameful. And I don't get a sense from you that you understand that the system is shameful in these specific respects. And I couldn't possibly describe a system that's shameful as being one in which there is room for improvement. It's one in which there needs to be root and branch structural reform. But that's not what you've been telling us for the past couple of days. And I would use this example as Exhibit 1. You heard Commissioner Hunter welcome children searching for themselves because they have been taken. And one of the reasons that they're searching for themselves is that they've lost contact with their country and their family. And if cultural plans were in place, that might not happen. They would not be searching. They would know who they are and what their connection was with their people and their country.
I completely accept that, Commissioner Bell. I think we've been, and I've been very clear about the shameful nature of many elements of our system. I've been very clear about the need for significant reform, and government has been clear about the need for significant reform. And that is a conversation that we are here to have. We are clearly wanting to do more in this space. But I do want to also balance that with the reality of operationalising either this system or any future system.
I think the reality, Mr. Alisandratos, is that when these kids come searching, they're not coming to you, they're not coming to the department, they're coming to us as Aboriginal people, and we have to answer those questions. So anything other than strategic changes of not only the Aboriginal Child Placement Principle, but how that's implemented on the ground is unacceptable, because you've just said 66. I'm not going to let you explain that away. It's just unacceptable. And you should know, because alongside you, I have worked on that front line as well. They come back to us. They don't come back to the department. They come back to us, and we have to explain the actions of the state. It's not on.
Could I just ask that the Act be taken down for a moment? We will bring the Act back up shortly. I just wanted to take it down for this conversation. Is there a need to incentivise the workforce who are doing this work, this critical work?
So I'm just struggling with the word incentivise, Ms. McLeod, because we expect our workforce, both our child protection practitioners, and our Aboriginal community controlled workforce, which are so critical to this effort, to do significant amounts and to juggle significant demands. And that is an operational challenge that we all face.
So, given the pressures and the complexity of the system across the whole workforce, including those First Nations members of the workforce,
Yes.
what measures have you taken to support that workforce and encourage people to apply to those positions?
So we continue to invest more in that workforce, just like we've invested across the whole sector, but there's been such significant growth over the last few years that the challenge of workforce supply is a very real one.
So
That word growth is our people overrepresented in the system. Offensive to hear that word growth.
But I'm talking about growth in. Yes, you're right.
Yeah, I am right.
Commissioner Lovett, but I'm talking about growth in the workforce that is that government has invested in to support First Peoples across the state, and in investing so significantly, it requires a pipeline of people to be ready and be able to be recruited to deliver on those services. And the challenge that we all face across government and non-government is a short supply of workforce to be able to deliver those critical services, and that has an impact on how we can get to an 100% target in this measure and many, many other measures. And again, that it's not an excuse; it's a reality. When you have 10% of your community services workforce not recruited to because we just don't have sufficient pipeline, that is an operational challenge that we all have to face, just like we have vacancies in child protection.
So I mentioned
To
the
ask
word...
a question about this. I'm sorry, I know you're being interrupted a bit and it's difficult. Would you accept that that Aboriginal children have a fundamental human right to knowledge about their own culture and identity?
Yes, I do.
How on earth can you say lack of resources is an excuse for breaching a fundamental human right?
I'm not saying lack of resources.
Or,
I'm saying...
Which is exactly what you said.
I'm saying, so the resources might be there, but our capacity to recruit to those resources, given the workforce challenges that we have, given the growth of investment and the need for more workforce, can be challenging.
Okay, let me put it another way. Would you accept that it's the state's responsibility to give effect to respect, to protect and to fulfil the right of every person, especially Aboriginal people, with respect to their own culture, their own identity, their history, their land, their country, their families, their mob? Do you expect that's a state responsibility?
Yes.
Well, how can there be an excuse for the state failing to put in place the system necessary in order to give effect to that responsibility?
So what I would say to that, Commissioner Bell, is that the system is being put in place. Our ability to effectively resource and maintain continuity of workforce can compromise the delivery of that aspiration. And that's a reality.
Well, it's the state's responsibility to address that problem, isn't it?
Absolutely.
Just as it is with respect to all other aspects of complex public administration.
Absolutely.
Education, housing, health, it goes on and
Absolutely. And there are a range of workforce strategies that are in place across our organisation, our department, and many, many other departments, and at the whole of government effort. We are all working to increase the supply of qualified, capable workforce that can deliver these critical services that government has invested in.
On every occasion, when the Commission has gone on country and received evidence from families and received evidence from people, young and old, and gone to prisons, we have received evidence from people with tears in their eyes about this question.
Yes.
And how profound has been the impact on them of losing contact with their country and with their families, and how significant a factor that was in drug abuse and in offending and other such behaviours. And I have in my own mind the precious gift on a number of occasions of speaking with people about these matters. And then the flip side to that is how empowering it was and how healing it was for them somehow to be successful in the search of which Commissioner Hunter spoke. So this is not a question of room for improvement. This is absolutely fundamental. And I with respect, I don't get the sense of urgency and pressing concern in your evidence about this matter, and I've already made the point about some others. A system which produces shameful rates of removal of Indigenous people from their family is a shameful system, and it's shameful in this respect.
Can I just ask, Thanks, Commissioner Bell. We spoke about the responsibility of writing up the plan and getting... Whose responsibility is it then to implement that plan?
So the plan is, the implementation of the plan is the responsibility of the care team and members of the care team, because all of them will have a different contribution to make, including our Aboriginal community-controlled organisations who will implement elements of it.
So it goes back to their responsibility, and is there funding with that responsibility to make sure this child has the connection that it needs?
There is funding. Of course, the question about adequacy of funding is always an issue and a challenge.
But as Commissioner Bell just pointed out, it's a human right. It's a cultural right. It's a right of First Peoples to be connected. So money, rights, it's just not adding up for me. So it's it's written up. The responsibility then lays with the care team, or maybe contracted to an ACO. It lays with them. And there's probably, I would say probably, maybe you can correct me if I'm wrong, inadequate funding to be able to implement this.
At times, there can be challenges, yes, and inadequacy of funding. The only other element that I would add to that, as we move and transition more children to be looked after by Aboriginal community-controlled organisations, at the moment we're at nearly half of those children being cared for and or case managed by Aboriginal community-controlled organisations. By the very nature that they are being cared for and case managed by those Aboriginal community-controlled organisations means that they are getting more cultural appropriate service delivery. They are, by the very nature, more closely connected to their culture and community. So that there are some. If you think about the transition that we've had, Commissioner Bell, and where we want to go, the aspiration of having all Aboriginal children looked after by their communities, in their communities, will absolutely fulfil in a more tangible way their connection to community, because they won't be looked after by non-Aboriginal services.
That's extra work on their caseload. That's a cultural load that you hold as an Aboriginal person as well. And I hope there's money going into that Aboriginal staff for the load they have to carry to be traumatised by what's been happening to not only... We spoke about transgenerational trauma yesterday and how that's factored in as a risk. Yeah. I hope the government's putting money in to make sure that Aboriginal staff have enough adequacy to be able to be cared for in these spaces of trauma.
I absolutely agree with that point, Commissioner Hunter. So if we think about, just to give you an example of the differences, if we think about ACAC and the resourcing model that supports Aboriginal children and Aboriginal care providers, the typical caseload for ACAC practitioners is 8 to 9 children. Typical caseload for child protection practitioners is anywhere between 15 and 18 children. And that gives you an indication of both the significance that we've applied to how we resource ACAC providers to undertake the work in a very meaningful way, and to give consideration to both cultural load, work with families, and the intensity of that work in recognition of what it takes to get outcomes. That's why it's been resourced in the way that it has been resourced. So it goes to your very point about, and it goes to the conversation we had yesterday, this is not just a handballing exercise from the state to Aboriginal community-controlled organisations. It is a carefully considered and transitioned approach that we will take.
Thank you, Councillor.
And And if you, just to add, if you think about that difference in caseload, then it goes to some of the challenges that we face in doing all those meaningful elements of practice that are so important and meeting critical targets. Now, again, it is an operational reality that we've got to tackle. That's our reality. That we've got practitioners with significant demand responsibilities, and we've got to continue to invest in that to make sure that we are bringing the right focus, the right resource, the right attention, and government has done that, incrementally increasing the number of our practitioners and over time bringing some of those caseloads down.
So, if I can, Ms McLeod, sorry to interrupt you yet again. Just a quick question when you talk about investment, and there was the Bring Them Home report, which had 54 recommendations, and then there's Always Was, Always Will Be Koori Children, 77 recommendations. Out of that lot of recommendations, how many are implemented?
Let me just find that for you, Commissioner. So if I talk about the two significant reports post Task Force 1000, Always Was, Always Will Be, and in the child's best interest, there were 79 recommendations for Always Was, Always Will Be. There were 54 in the child's best interest. That's 133 recommendations, of which government accepted 128. Of those 128, 104 have been fully acquitted.
When you say fully acquitted, to whose standard?
To the standard that was established between the Commission and the ACF, which required a collective view and assessment about acquittal, adequacy of acquitting each and every one of those recommendations. So there was a mechanism put in place by Commissioner Giacomos in his time to work through the determination of what evidence would support the acquittal of those recommendations.
So you said 104?
Said 104 of the 128 have been fully acquitted. There are a further 19 that the department believes are ready to be acquitted, but we are engaging with the Children and Young Persons Commission to determine an agreed view on that. And there are 10 that are continuing to be in progress. A number of those recommendations that are in progress will be acquitted through the passing of the Statement of Recognition Bill.
But we've seen numbers go up, so do you think they're implemented, I mean, they might be acquitted, but they're implemented correctly? Because the numbers of children have risen since those reports.
Yes, I accept that. Have they been implemented accurately? They certainly have been implemented across the practice and operational environment. Are they having the impact that they were envisaged to have? That is a continuing area of examination for us.
So you're I guess, evaluating those as...
Yep.
And is that internally or externally evaluating them?
I think that the process of evaluation is an internal one, but there are external inputs into that evaluation through the work of the Children and Young Persons Commission, through further inquiries that are undertaken, where there is a focus on our work.
Thanks.
I think the question was also about the Bringing Them Home report and how many of those recommendations have been implemented. You referred to Task Force 1000.
Yes.
By Commissioner Giacomos, noted, and also Our Youth, Our Way. Was that?
No,
what
in
was
the
other
child's
one?
best interest.
Child's best
Yep.
interest. So, what about the Bring Them Home report?
I don't have that in front of me, but I understand that those recommendations are much broader than the children and families system. These are more specific within the context of the delivery of children and families in the state.
There still would have been
Absolutely.
commitments for that department
Yes.
to be accountable.
Yes, sure.
You know, we don't want to. We don't want to get into another VAF conversation like yesterday, where it's no one's responsibility.
Yeah.
A number of matters arising from that, pardon me, conversation, and I wonder if you would undertake to follow up for the Commission on a number of things. In respect of the 34% of children with no care plan, no care support plan, can you provide information about the percentage who are not delivered within 19 weeks and the identification of any reasons, if the department knows them, for non-delivery within time?
I could be wrong, Ms McLeod, but you may already have that.
Confirmation of the number?
Yes.
Yes. Can you provide details of any research projects into genealogy that are in the pipeline and any plans for collaboration with academic institutions or other researchers? Can you provide details of the department's investment in the workforce, including any recruitment and retention plans? And can you provide information regarding any plans and timelines for the transfer of power to ACOs and CSOs and any additional supports to accompany the development of cultural support plans and the Secretary's powers generally? All of those things.
Can you just repeat that last one?
Yes.
Yeah.
So the question about you mentioned in one of your answers that you are transferring powers. You mentioned in your evidence the role of ACOs
Yes.
in developing these cultural support plans. So in the context of the transfer of the Secretary's powers to
Yes.
ACOs and community service organisations, if they hold those powers
Yes.
as well, can you provide us with information about the development of these cultural support plans and how the transition of power is being affected?
Right. Okay.
Okay, all of those things.
Sure.
No problem.
Ms McLeod, can I just ask, and I don't know if we've already got this, but how many, of all the Aboriginal children in out-of-home care, how many of those cases sit with the department and how many sit with ACOs?
Yes,
that
we've provided that, but
Oh,
we've got about 47% of Aboriginal children, First Peoples children in care being looked after by Aboriginal community-controlled organisations.
Thank you.
So that was just the first aspect of the consideration about Section 11A, the assistance and support to be provided to a child's parent to promote the child's safety and well-being. The second aspect I wanted to touch on was measures taken by the department or planned to be taken by the department to address racism and bias, conscious and unbiased. Now, you accepted yesterday that racism and bias in the department and in its operations is intolerable. Can you tell the Commissioners, please, about what is currently done? And you might refer to not just policy references and policy documents, but I'm interested in mandatory or prerequisite qualifications that touch on those subjects. I'm interested in training, induction and continuous professional development measures. Commissioner Bell.
And racism is not just morally repugnant, it's a fundamental human rights violation, is it not?
It is.
So the question, besides the ones that have been asked, is what are you doing to uphold the law with respect to that matter?
Yes, thank you. So there's a number of elements to that question, I think, Ms. McLeod. So if you can break it down.
Yes,
for me.
certainly.
So if we start with...
Let's start with, there is an acknowledgement that racism and bias in the operations of the department is intolerable and contrary to law. What measures is the department taking to address those biases and racism that you know exist?
So can we go with that one? Just
Yeah. So start with that. I don't need you to take me to the policy documents because I'm aware of where there's reference to those things in the written documents.
Yes.
I'm interested in how you actually address those biases held by your staff that infect decision making.
Well, let me take you through some of the training that we obviously expect our staff to have. So all our staff are required to undertake cultural awareness training. There's a number of e-learning elements to that, particularly at the commencement and through the orientation programs that are provided by the department. There's cultural safety training for managers, which is mandatory for all people managers, and that is an important element of input that we provide our managers so that they have an understanding and are able to identify any bias, any racism, and they can deal with it. In child protection, staff are provided more specifically with cultural awareness and cultural safety training, and it is an essential part of their professional development. This is undertaken through what we call the beginning practice induction program, which currently includes a working with Aboriginal children and families session that is developed and implemented and delivered by First Peoples to provide that direct input. In the context of that training session, there are case studies that are used to support the way that practitioners ought to engage and work with First Peoples families, and use the use of those case studies are an important way of creating an understanding about both history, context, and a better understanding about the engagement with First Peoples families. There are a range of child protection practice forums, and generally these are online practice forums that are designed and delivered for our practitioners to increase the proficiency and capability around working with First Peoples children and their families. And we did a number of these, particularly in the context of COVID as well, to bring much more sharpened attention during that period of time. There is input and training around cultural planning, and this is delivered by the Victorian Aboriginal Childcare Agency, First Nations staff members, and our own First Nations staff members as well. It's a jointly designed and implemented and delivered module, and we've got a range of presentations and training that we offer to our after-hours child protection staff as well. Through our what we call our career advancement program, and this is a yearly mentor development program for aspiring practitioners who want to move into more senior roles. One of the 6 modules that we undertake training in focuses directly on unconscious bias, and is delivered by Mahana Culture, a First Peoples organisation, and includes consideration of Aboriginal cultural safety within the context of those aspiring practitioners who want to progress, given the importance of how we want those practitioners and managers to be engaging, not just with families, but with their teams and imparting that knowledge as well. There are new programs focused on strengthening child protection practice with First Peoples children and families that are going to be offered and are starting to be offered through this year. So this is again a continued revision and addition of additional programs. We have a series of 30-minute child protection forums focusing on the Aboriginal child placement principle, and each of these sessions are presented and delivered by First Peoples staff members, and we record those and we make them available to the broader workforce. We are in the process of procuring the development and delivery of a new cultural safe practice for child protection training program, and that training program will be developed in 2023 and delivered to all our child protection practitioners over the course of the next 3 years. And we have implemented a new e-learning module that is focused on asking the question around identification, and that is currently being implemented as well. There is a new child protection practice induction program that will replace the beginning practice program later this year, and our statewide practitioner for Aboriginal children and families has overseen the cultural awareness and cultural safety curriculum of this program. There are 4 modules that relate specifically to child protection practice with Aboriginal children and families, and these modules will be delivered by Aboriginal staff and Aboriginal guest presenters. These modules focus on developing an understanding of Aboriginal Torres Strait Islander families and communities, on practising with Aboriginal and Torres Strait Islander lens, collaborating with First Peoples families and communities, and the topic that we were just talking about, developing effective cultural support plans for First Peoples children.
So the one you mentioned of the 4 modules, is that the cultural safety training curriculum?
Yes, that's right. Yeah.
Now, it sounds like a lot of activity. Can I invite you to look at paragraph 115 of your statement?
Paragraph 115.
115. Under the heading of conscious and unconscious bias and insufficient cultural understanding and competence, you state, importantly, I acknowledge there is insufficient cultural understanding and competence across our system. While there has been an increased focus on professional development and training, discussed later in my statement, the cultural competence of the workforce has resulted in failures to understand and respond appropriately to First Peoples families, and is likely to be driving reports, higher rates of substantiation and intervention. While it is difficult to quantify, I do accept given accounts by First People over my professional career and our increasing rates of overrepresentation that both conscious and unconscious bias and racism still exist in our service system as it does in the broader community. As noted above, attempts should be made to research how these factors influence child protection decision-making, including seeking the views of First People directly, and at 116, the pervasive impact of racism and unconscious bias on practice was highlighted by Ms Felicia Dean of Rumbarala. Her evidence was, one of the other problems is this white lens is used to assess everything. Often that white lens is grounded in a basis of prejudice and racism, and unconscious bias. It's there, and there are lots of examples of that. You acknowledge the important truth of that statement and the contribution of the white lens to overrepresentation, and in conclusion at 117 you say, all the factors I have mentioned combine and they build on each other. So we see a compounding effect as children move through the child protection system, culminating in the very high rates of First Peoples children in care. Now, given the long list, and I do want to touch on some of those trainings and induction methods, given that long list that you've read, is it your evidence that you're onto it and what you're doing is sufficient? Is your evidence that you don't know yet whether you will be addressing racism and bias in the system until you see the results of all these programs?
I would say that we understand it is an issue that we need to tackle. It's an issue that has been given even more prominence through the additional focus that we have on training our practitioners, on providing them with the right input, and ensuring that we stamp out any racism or bias that may exist across our workforce. I should qualify some of that by saying that some of that commentary related to a number of other factors in the preceding parts of that statement that talks to a number of drivers of overrepresentation. So I know you're focusing more specifically in relation to this element, but when the sort of summary paragraph at the end talks about the compounding effect of multiple drivers, including systemic racism and bias. I just want to be clear about that.
But the programs that you've listed for us and the investment in the training, those go to the broader factors as well, correct?
Yes, absolutely.
They're intended to address overrepresentation.
Yeah, that's right.
Can I come to some of those factors then, some of those programs at 351 of your statement? You're addressing the question about cultural awareness and cultural safety training provided to staff. And at page 351 and 352...
Are you talking page or paragraph?
Sorry, paragraph 351, 352. Yep. There's a discussion about the qualifications required for a child protection practitioner, things like social work, degrees, diploma of community services and so on, but there's no specific prerequisite for an employee of the department to have any sort of cultural training. Is there any cultural understanding or any component of a prerequisite course that they come to you with that information? And to be fair, if you look at paragraph 353, there's the reference to some tertiary providers incorporating Aboriginal and Torres Strait Islander studies within their major courses. Yes. But it's not a prerequisite, is it?
It's not a prerequisite. But we do, as we engage with our tertiary institutions, we do have an expectation that cultural elements are built into many of these curriculums.
As core components, mandatory components of the course, or as components,
options? How do you quantify that statement?
How do you assess whether they're doing that?
We don't assess it, but what we rely on a number of qualifications that are relevant to the delivery of child protection practice, and continue to have engagement with tertiary institutions about the curriculum makeup, where we do talk to them about the need for cultural competency to be part of those curriculums.
So a person fresh out of those courses may have had no or very limited exposure to First Nations persons, cultural plans, cultural issues
I-
generally?
Yes,
They may
that
have
is
nothing.
that is possible. Yes.
Can I just, so you've mentioned all these that everybody has to go through, which brings to mind two questions. Does DFFH have any reporting mechanisms for child protection staff to report racism they observe on their colleagues? And the second question would be, how do you monitor and measure the staff proficiency in working with First Nations families and children? So you've got all this in place, but how do you make sure? So that would be my two questions, sorry.
I think I mentioned yesterday there are supervisory structures within the service. Those supervisory structures are important for professional development, for supervision of both practitioners' practice, their administration, and the work that they do with
Is
with
that
families.
safe enough? Just, sorry to interrupt, but is it safe enough? So if say I was a child protection worker and I saw some racism happening over here,
Yep.
and then I went to my supervisor to say, hey, that was pretty racist from my account.
Yes.
Is that safe for a person to do that within the space?
It's hard for me to say whether that's safe, Commissioner Hunter, but all I can suggest is that those structures are important elements for how we ensure the quality provision and the cultural appropriateness of that provision. We have invested in putting in place a number of First Peoples practitioners within the service as well. So we have Aboriginal advisors now that are embedded within our child protection teams. We have AFLDM practitioners. We have a number of First Peoples practitioners who are now working alongside our child protection practitioners, and that has the effect of doing a number of things. One, it continues to raise awareness, it builds capability for our non-First Peoples practitioner base, but it also helps to identify systemic racism and bias that in a supportive environment can be called out and can be targeted and actioned where that is in existence.
So with all that training, the second question was, do you monitor and measure the staff proficiency of working with First Nations children and families?
Again, largely through the process of those supervisory structures. Those each practitioner reports to
It's just through
their line
supervision.
supervision,
Is that what you're saying? Just
and
through the line
that's the
supervision?
accountability structure. So that's where a practitioner's performance is assessed on an annual basis with a process for both supervision, improvement, and then any remediation activity that needs to be undertaken if there are issues that are identified through that supervisory accountability structure.
And just with those First Nations workers, how many of them, and you've probably answered this actually, I should go and have a look, but how many of them have actual authority in positions of just not being practitioners or advisors?
Do you mean how many of them are in senior roles?
Yes. Yes, thank
Yes, we've provided that information, but I can find it for you. But about 2% of our workforce is made up of First Peoples staff. It's not a big number, clearly, and it is something that we continue to be focused on, how we lift the number of First Peoples that are working within the service. That's been helped over the last little while because we have had some additional investment that have brought in those 18 senior advisors, Aboriginal advisors within the service as well.
2%, your stats are getting lower.
Mentioned a bit. Hang on a moment. You mentioned a bit earlier about the Aboriginal staff delivering some of these models in the training, the suite of training that you referred to.
Yes.
Is that their core roles to do that, or is that something that they're doing on top of the roles that they've spread diverse across the department?
No, that is a core role. Our Office of Professional Practice has an Aboriginal principal practitioner. It's that individual's core role to be both supporting, oversighting practice, but also contributing to curriculum development and training development. And then there are numbers of people within our corporate and delivery service that support the development of those modules as well.
Yep. And more broadly, how are you, as the department, monitoring, evaluating the effectiveness of cultural safety, cultural awareness training and things like that?
Yeah. There are periodic evaluations of each of our training modules. We obviously seek feedback from participants to those. We check in with our supervisory management structures to get input about whether these modules are hitting the mark, whether the training provided is fit for purpose. And
we're asking the individuals you're asking the individuals of cultural awareness training and cultural safety training if it's hitting the mark for them.
Well, we're asking a number of different parts of the organisation, both individual participants as well as their supervisors and managers, as well as our First Peoples staff across the organisation as well.
Can I just ask, the current modules, the ones that they have in induction and the others that are mandatory for management, how are they assessed?
How are they assessed?
How do you assess whether people pass them or not? Is there any assessment of how people do in those modules?
They're not designed in that way, Commissioner Walter. They are designed for raising awareness, raising proficiency, and then the assessment goes back to the supervisory accountability structures that we have in place.
So they just do the module?
They do the modules.
Yeah, and that's what I was trying to get to around understanding, how are we monitoring and evaluating that? Because the data's not changing. I keep coming back to that yesterday and today. The data is not changing around the overrepresentation of our people in the system. And how are we quantifying that cultural awareness and cultural safety training is clearly not enough.
Can I suggest that Commissioners hold the thought for a moment? We will return to this topic. It's probably an appropriate time to have a break, 20 minutes.
15 minutes.
15?
Thank you.
Which leads to 20.
Chair.
Thank you, Councillor.
So before the break, there was consideration. I just want to stay with the various programs that you've raised about racial discrimination, racism and bias, and complete that. But I do want to loop back to the numbers of cultural safety plans in a moment, because I know there's an issue about that. So in terms of the prerequisites, I asked you about prerequisites, and I think you agreed in effect that a person employed fresh out of one of those prerequisite courses may have no or limited training or knowledge in respect to First Nations persons and culture.
Yes.
Yeah. Would you consider that some sort of mandatory First Nations cultural safety training should be a prerequisite for employment?
Yes, I think that would be desirable.
And the department could work with the providers of the curriculum for those prerequisite qualifications to design those courses with input from Aboriginal organisations, of course?
Yes. I think any work that we can do to increase the cultural proficiency of future workforces will benefit First Peoples, absolutely.
Okay, could I ask you to turn to paragraph 355 of your statement at page 83. Just got a bit of feedback on someone's microphone.
No,
I think it's drilling.
Drilling, great. Sorry about that. At 355,
We need to let Chris know. I think, sorry, Council, we might be able to get Chris onto that, do you think?
Yeah. It's okay, she's got it.
Is there?
Catherine, could you?
She's got it,
advise-
she's
yeah,
got it.
Thank you.
it's probably bad enough for Mr Alisandratos without feeling like he's at the dentist. So at paragraph 355, you make reference to cultural awareness, cultural safety training provided to child protection staff, including all new employees required to complete an e-learn unit. As part of orientation, all managers required to complete cultural safety for manager training, and cultural awareness and safety training is available for all staff. Those training packages were developed by Koori Heritage Trust, aligned with Aboriginal Cultural Safety Network. So the reference first to cultural safety training curriculum and learning, the learning outcomes for that course, which is DFFH.0005.0001.0778. I don't need to have that brought up on the screen, but just to let you know, the learning outcomes for that course are A, what is Aboriginal cultural safety and its importance in the workplace? B, why Aboriginal self-determination is important? C, key policies and procedures to embed Aboriginal cultural safety at work and in service delivery. And D, what can you do to support Aboriginal cultural safety at work? Now, is this the e-learning course that has been implemented, or is still to be implemented?
Without seeing the document you're referencing, it's hard for me to make a view of it. But I think it is the e-learning cultural safety.
Could Mr Alisandratos be shown the document at tab 36, please? Tab 16, I'm sorry.
Melanie?
So this is been provided an answer to a specific question about cultural awareness, cultural safety training, and the document sets out the curriculum for cultural awareness and cultural safety training. You see under the heading, the 4 learning outcomes that I've just read out. This is apparently an e-learning document, an e-learning course, I'm sorry.
Yes.
Is this one that is currently implemented?
Yes, my understanding it is currently implemented. This is as of February 2023.
And just to follow up on Commissioner Walter's question, is this one that you don't assess competency for?
There are no formal assessment of competency.
Is there a record of completion for staff?
I believe there would be.
And to complete the e-learning program, do you have to click through various pages and answer questions as you go?
Yes, that's my understanding.
And is there a
It's
mechanism?
both content and questions, yes.
So is there an internal mechanism in the program that you can't proceed unless you get a question right, or is there feedback if you get an answer wrong?
Typically, there is the opportunity to answer the question. You will get feedback about whether you've answered the question correctly or not. More information will come up. That sort of process is undertaken.
And is there any other, apart from the question and answer, is there any other test for competency following completion of this e-learning?
I don't believe that there is a formal test for competency, if that's what you're asking me.
Yes. You say at paragraph 357...
Excuse me, Councillor, can I just, so how long would this take for a person, a worker to do, the average worker? How long would they take to get through this module?
I wouldn't have the precise time, Commissioner Walter, but an hour and a half. Yep.
It's quite a short.
Yes, yep.
So that's an hour-long course to cover those four topics?
Again, without having that precise information in front of me.
We're not talking about days and weeks?
Having done a few of them myself, they take anywhere between an hour, 2 hours. Yeah.
You say at paragraph 357, all child protection practitioners and managers who are new are required to complete the beginning practice induction program, which includes components on First Nations family. Now, the document that you have in front of you, as I understand it, describes cultural safety training curriculum as well. You address, first of all, the cultural e-learn, then you address cultural safety for managers, and then you come to Aboriginal cultural awareness.
Yes.
And beginning practice in
Yes.
child protection program. That's the one we're talking about
That's the
now?
one.
Okay. That is presented, as I understand it, as a single module,
Yes.
and it's presented by First Nations staff.
Yes.
It discusses the importance of culture, context and history. I'm down towards the bottom of the page. Aboriginal placement principles and cultural plans.
Yes.
Is that module also of similar length, an hour or so?
No, because that is not an e-learn module.
Right. That's
It's a
actually
delivered
presented live.
Yes, that's right.
So how long does that take?
I don't have that information.
If it's presented live, do you assess competency as a result of completion of that module?
I don't believe there is a formal assessment of competency on any of these modules.
Would you agree there should be a periodic requirement for staff to undertake continuing professional development that covers cultural safety delivered by VACA or some other similar organisation?
Yes, I do.
Do you agree that there should be some measures of proficiency of staff competence in cultural safety put in place?
I think it would be desirable that the effect, how you would manage something like that within a workforce of 2,500 would have to be worked through.
So you need some input from educators and trainers. Have you had any conversations with the Victorian Yoorrook or with the Australian Human Rights Commission Race Discrimination Commissioner about the design of surveys of the workforce, those 2,000 plus people, and ways to address race in the workplace, racism in the workplace?
I'm not aware of any specific conversations.
Do you think that would be a good idea?
Well, there are there are a range of engagements that we have with Yoorrook through the department on a range of different matters. I'm happy to go back and understand whether there's been a specific engagement and conversation on this matter.
Okay.
But even if there has or hasn't, I think the original question was to you, do you think that that should happen?
Yes.
Is that the question?
Yes, thank you.
Yeah. So I
Yes.
just want to get an answer, yes or no.
Yes, but I qualify that because it may already have been put in place. I'm just not aware of it, Commissioner Lovett. So yes.
Thanks.
I said under the discussion about section 11A that there were 4 things to address. One was the cultural support plans. The next was racism and bias. The other 2 were evaluation and research, and we may have already covered Commissioner's questions about those things. So just to come back to cultural...
I just have one more question
Yes.
there. I'm really bothered that there is no assessment of cultural competence, that the courses that are given are short, with no assessment attached to them. And I just wonder, is that how you approach, are all topics treated the same way, or is cultural safety treated differently to other requirements you have of your workers?
My understanding, Commissioner Walter, is that any of the training that we provide our workforce is treated in the same manner, and the competency and the performance of a practitioner is assessed through the accountability structures that we have in supervision and management.
Is there a specific cultural competency measure within that you use so that supervisors know that they need to assess cultural competency with their workers' assessments?
I'd have to have a look at that and see whether we've got something like that in place.
Would it be a good idea if
Yes,
it isn't
it
there?
would be.
Have you done this training?
I've done some of it.
You've done some of this training?
Some of it. Yep.
This one?
Not this one specifically. Not recently.
Well, it's only been out since, what was that, 20...
No, this is as of February. That's what's in place at the moment.
How important to the DIFA board is this training, or training in general about this?
I think, as I said yesterday, Commissioner Lovett, it is the cultural proficiency of our workforce is extremely important. It is something that we are very, very focused on and driving improvements. And as you can see from what I've outlined, we are looking at ways for increasing that proficiency, bringing more input into the department and into our workforce. And we will continue to look at ways to drive this beyond what we've got in place at the moment.
So is this all mandated training?
Yes.
And so if you're not a practitioner, you don't have to do it? Because you haven't done it. So I'm just wondering what the mandate is of who...
Well, some of this is mandated for practitioners. Some of it is mandated for all new entrants coming into the department as part of an orientation. So it's tackling it at both levels, because there are different requirements and different modules that we are providing our practitioners vis-a-vis other parts of the organisation.
If you're doing
Ultimately, to
policy...
use your words, it's still desirable. You've mentioned that word quite a lot today, desirable, which is not really committal, it's just desirable.
Yeah. Some of it is mandatory. So beginning practice is a mandatory requirement for child protection practitioners.
If it's not effectively evaluating and monitoring it, then it's, you can just turn up. You don't have to be engaged or you just be present, but you're not engaged.
Yeah. So the
way
question,
to quantify that.
You rightly call out the question about how we determine proficiency, and that is something that we need to have a look at.
Just staying with this document, to be clear, the induction for new staff and managers is mandatory. That's on the first page of the document. Over the page, Aboriginal cultural awareness is available, so that's not mandatory.
That's right.
It's just offered, and people can pick that up if they have interest or time or
Yes.
any other constraint that might be they have to navigate. then the beginning practice is the new practitioners, that is mandatory.
That is.
And as noted, some of these courses, the e-learning ones might be relatively short, an hour or so in
Yep.
time.
And some of them much
Depending on
longer.
how quickly
That's
you
right.
move through the model.
Yep.
It could be less than an hour, or it could be more. Okay.
Can I just ask a follow-up question
Yes.
on that? I know this is infuriating, Councillor. I do apologise.
I'm not infuriated, Commissioner, thank you.
Would you accept that, as you did earlier, I think I'm repeating a point I made to you earlier, that respect for culture, and not just that, but promoting it, is a fundamental human right possessed by children?
Yes.
And with respect to Aboriginal children, their Aboriginality, their connection with their place and their family and their culture is a fundamental human right that they possess.
Yes.
And this is protected by rights which you conceded existed yesterday, particularly CROC, the Convention on the Rights of the
Yes.
Child, but also protected in Victoria by the Charter. Your witness statement concedes properly that your officers exercising child protection type powers are bound by the Charter.
Yes.
And one means by which you give effect to your obligation to ensure that that law is not violated is through education programs of the kind that you're presently discussing.
Yes.
I haven't got the document in front of me, but I can't see anywhere there the instruction that it's a lawful obligation to have this knowledge and to act on it in the way that the department
Yes.
interacts with children.
Yes.
Is it there?
I'm not sure actually whether it's explicitly
Or perhaps
framed in that way.
Let's do
but-
this. Let's
yeah.
do this in order. You have the document in front of you.
Yeah.
It's
You mean
only-
this document?
I do. Yes. It's
Yeah.
only 2 or 3 pages. Could you?
Just to be clear, Commissioner Bell, this is a summary document.
Oh, I see.
It's not a source document.
Not a source
Yeah.
document.
So it's a
Right, well,
summary
let's
of
deal
what...
with it. Let's deal with it at the abstract
Yes.
level then.
Yeah.
I'm concerned to know whether this fundamentally important material is taught as a matter of good policy, which it plainly is,
Yes.
but also taught as a matter of binding law, which it also is.
Yes, I accept that. Whether we've made that explicit in terms of the way that it's framed, I'm not sure, and
Would you take that on
yeah,
notice?
I could.
Yes, thank you.
Yeah.
Just to follow up on Commissioner Bell's question, you would be concerned that your workforce was aware of legislative and other legal requirements in the fulfilment of their duties, would you not? You'd be concerned that those practitioners know what their legislative requirements are.
Absolutely.
What the law requires.
Absolutely.
And there is a risk, if those practitioners are not observing the law, that exposes the state to civil litigation, is there not?
I accept that, but just to be really clear, part of the beginning practice program is having content that goes to those very issues, the legal mandate, the legislative base.
Yes.
For practitioners' consideration. There is input that is provided to our practitioners about what the legal basis of their practice ought to be, and that includes both all provisions that are included in the Children, Youth and Families Act, as well as the Equal Opportunities Act as well.
So the average retention of your workforce is around 2 years?
I've got to come in here. You're going on to another topic. I have to go just to one thing.
Yes, thank you, Commissioner.
I think we can say with certainty that it's not a learning outcome that departmental officers know their legal human rights responsibilities and the connection between culture and human rights, because it's not there specified.
And you can't quantify it.
You can take that on notice if you like.
Sure.
It's just that I have that much of the document there.
Yes.
And learning outcomes reflect curriculum.
Yes.
So I'm working back from the outcome to be suspicious
so
of the content of the curriculum.
So my only caution, Commissioner Bell, is As I said, it is a summary document. You'd have to go back and
All
look at all the various source
Right.
documents
Perhaps if you could
that
take
relate
that,
to
take that,
learning
that particular
outcomes. Sure.
outcome, that particular aspect on notice. Thank you.
So just
Councillor.
back to the mandatory training, we
Yes.
get that there's no monitoring evaluation mechanism for the Aboriginal component. Broadly in the department, other mandatory training, can you give me an example around when you are monitoring and evaluating that training that's not Aboriginal specific?
Beginning practice is all inclusive, if you like, in terms of what we provide our practitioners, in terms of the requirement for them, mandated requirement for them to undertake that training before they take on a caseload of families, and that is the application is the same across the board for that.
So you have the ability in other areas to monitor and evaluate mandatory training, we're just not doing it in the Aboriginal component?
No, what I'm saying is the opposite, that it is the same approach that we take for all our training. Yep.
Thank you.
Does the department track the individual staff members' compliance with continuing professional development generally?
Part of the requirement is for staff to have a learning plan as part of their professional development, and in the context of supervision, those elements are incorporated in the supervisory relationship, and attention is paid to what professional development needs to be undertaken by each of the practitioners, and it is a core responsibility of the supervising officer to monitor that, work with the practitioner or any staff member for that matter.
So it might be useful, do you agree, that there's some sort of red flag system for a supervisor to ensure that this optional training in Aboriginal cultural awareness is taken up at regular points?
Yes.
To have a system where you have training and induction and then years could pass before you have a refresh on these things, which include the legislative requirements and the charter requirements, is undesirable, I suggest. You agree with that?
Yes, if that was the case, yes.
Okay. Now, I just wanted to come back to the discussion we had before about the cultural plans. At 358 of your statement, paragraph 358. Oh, sorry, not specific to plans. This is still on the question of education. You say child protection practice discussions, which is one of the things you mentioned in the list of activities, are fortnightly half-hour online practice presentations on different topics, themes relating to child protection practice. 3 child protection practice discussions relating to working with First Peoples children and families have been delivered since 2020. So, so far, assuming that we're close to 3 years or around 3 years, only 3 sessions have been presented on that topic in those practice discussions. So is there some rationale for why only 3 times the agenda has included those discussions?
No, I think the last sentence in that paragraph talks to the recordings of these being made available on the Child Protection Learning Hub. The Learning Hub is the source of all training material that is provided to for our workforce.
There's some requirement that staff check in and follow those discussions?
Yes, and so that goes back to the earlier conversation about through the process of supervision and through the supervisory structures and through the professional development elements of that structure, a supervisor would be talking to a practitioner about revisiting some of those training.
So do we know whether that's happening or not? That the supervisor says, oh, I notice you haven't checked in on your review of this online discussion about cultural safety, you better get around to that.
I would say each supervisor would have knowledge of their team members.
Could you track that down for us and just tell us whether there is a mechanism to assist both the supervisor and the practitioner to ensure that those sessions are followed up?
Yeah, I'm not sure that there would be a mechanism where we collate all of that data.
No, I just mean on the individual, the supervisor is
At
managing
the individual
development.
level.
Yeah, because as I understand your evidence, the supervisor is managing the child protection practitioner's compliance and continuing professional development.
Yes.
And is there some mechanism to assist a supervisor that says they haven't undertaken cultural safety training yet? They haven't looked at the online discussion that's been posted that happens once a year. You better give them a nudge to make sure they do that.
Sure.
Okay, thank you. Just to come back to the numbers of cultural safety plans, the figure you gave the commissioners was 66%, and I understand there's some issue about 66% of what and what is the data pool you're assessing. In paragraph 204 of your statement, recognising that this is a number that might change depending on the cohort you're measuring and so on, paragraph 204 of your statement, the figures from Task Force 1000, of course, do not include all First Peoples children in care.
No.
The sample there was only of 980.
Yes.
That's the title, Task Force 1000. So 980 children in care were the cohort, and the figure that you give there at the last dot point on page 51 is First Peoples children with a cultural plan has increased from 18% to 50% there. You see that?
Yes, I do.
So as at 31 December 2022, of the 2,365 First Peoples children in out-of-home care, 52% of those had a cultural plan. Is that the effect of that paragraph?
I'd have to check that just in light of the conversation that we were just having, because it depends on the timeline that particular point relates to. There is a bit of variation between the numbers depending on what we're measuring, whether we're measuring compliance to the 19-week requirement or whether we're managing any children who across the system who have a cultural support plan, and that varies from the 66% that I was referencing anywhere to 75% when you take the different measures. So we'll come back to you on that.
That would be useful. And also, could you indicate which data is regularly held and which data should be regularly held so we can make the comparisons and so that the department itself can conduct audit and assurance?
I could be wrong, Ms McLeod, but I think we have provided the full suite.
I don't think we're allowed to talk about it yet. So
I'll have a look at that, Madam. Yeah.
Thank you.
Can I just ask something on the compliance, because it's the national standards for at-home care, and I'm not sure, I've got an old one in front of me, it's not from 2020, but in this one, there's 13 standards, I think, and one of those is around plans generally for children. And then there's the standard 3 is Aboriginal and Torres Strait Islander communities participate in decision-making in placement of their children.
Yep.
There's all this. So I'm thinking with the training, with the employment of the 2% staff, with or everything that's going on and the improvements that are happening, and you've got the national standards for out-of-home care. Who audits these national standards for out-of-home care? Because am I correct in saying that out-of-home care service providers have to reach these standards as well as DFFH?
Yes.
Okay, so who audits the national standards that are they being met by DFFH?
Yeah, I'm not totally certain about which standards you're talking about.
They're the
Commissioner
national
Hunter.
standards for out-of-home care. I've got an outline,
Sure.
an old one. A priority project under the National Framework for Protecting
under
Australia's
under
Children.
the national framework.
Yeah,
Yes.
sorry.
Yeah. No, that's okay.
So there's so many plans, I'm getting
Yeah.
confused.
Yeah.
So standard 3 is about Aboriginal and Torres Strait Islander communities. There's a heap in there which applies to every child in care, but there's some specific ones. So if that standard has to be reached by the organisations, the out-of-home care organisations and DFFH,
Yes.
who audits that they're reaching these standards?
I'm not sure that there is an audit function as such. I think there is a national measuring framework and a national reporting framework that we all have to report to
So do the...
based on the measures that are defined through the national framework.
So I guess with all this measuring, and we're talking about, putting measure... My question really goes around, on these assessments, are there Aboriginal and Torres Strait Islander or First Nations people part of these assessments? If you've got standards, this is just one, and you've spoken about all these other things,
Yeah.
and you're saying we're consulting to do these, are there Aboriginal and Torres Strait Islander or First Nations people that are part of not reviewing, assessing, evaluating?
Yes.
Yeah.
Yeah. I without speaking specifically to that specific issue, I know that when we're undertaking evaluations, it is our practice that First Nations people are always included in those evaluations, particularly as they pertain to the delivery of services to First Peoples.
And just so I understand, the out-of-home care providers,
Yes.
are they assessed against these or held to by the department? The department
There are a range of service delivery standards that providers who receive funding from the department are held accountable to.
the department. So ACCOs, for instance, that
Yes.
get money from the department, are held to these standards.
They are.
And so who holds DFFH to these standards?
There is a similar mechanism of evaluation and audit of the department as well.
Okay, so you just said there was measures, like...
I was talking about that specific.
That specific one, okay.
Yeah.
By whom? Who does it?
There are independent auditing bodies that...
Like who, for an example?
Just trying to remember the name of the organisation. There are a number of independent auditing bodies that are responsible for undertaking audits of the human services standards. And in future, we will have an independent regulator across the whole social services environment as well. So,
Right now, it's an independent, and then they just report back to the department?
yes,
And they do that annually, biannually?
on a triannual basis. Yep.
That's all for now. I'm going to dig up the latest one because there's, for me, I think everything hangs on these standards because everything's in there, the stability and...
Yep.
We'll get
Could
that
we see
later.
the latest independent evaluation? Would that be something you can provide for us?
Sorry, the
latest independent evaluation
of some of the of standards, yes.
To come back to the question of data and the uniformity of the need for it to be uniform, consistent and useful, the Commissioner for Children and Young People, Meena Singh, has suggested that it would be useful for her office to have input into what those data sets are. Now, if the Commission were to recommend that occur, that she have data into that, I take it you would welcome that input.
Yeah, sure.
Just on the cultural safety plans, once a child is in a permanent placement, is it the case that there is no further work done to ensure cultural safety plans are made, reviewed, implemented?
Yes, there is a requirement to have a cultural support plan
Which is
in
designed
place.
before a person or at the time of placement?
At the time of, well, and at the time of the court considering an application for permanent care order.
So the court makes an order.
Yes. The
At that time, there has to be a plan in place.
Yes.
And the court will supervise that.
Yes.
In its jurisdiction. After that time, once a child goes into a permanent placement, there's no review.
No, because the department ceases its responsibilities through the issuing of a permanent care order.
So the department will seek an order or support an order that a child go into permanent placement.
Yes.
Thereafter, the department steps back in terms of case plan, cultural planning, all of those aspects of care.
The issuing of a permanent care order transfers parental responsibility to the permanent carers. The secretary no longer has parental responsibility and as a consequence doesn't have any case management responsibilities.
Understand. So there's no mechanism for the department to ensure in a permanent placement that there's any attention paid to cultural safety.
Not beyond the court having satisfied itself that the placement is appropriate, it is culturally supported, and that advice is provided by the Victorian Aboriginal Childcare Agency.
Yes.
And there's a requirement for a report that supports the issuing of a permanent care order.
At the time of the order.
At the time of the order.
There's no monitoring or review of that beyond the order, is there? Beyond the time of preparing that
because
report? Because the department
parental
steps back.
responsibilities are transferred
Yes.
to the permanent care order, permanent carers.
So who, if anyone, is ensuring cultural safety of a child who's subject to a permanent placement order? Not the department, clearly.
Not the department. So it is, the onus is on the carer, the permanent carer, who has parental responsibility to implement the cultural support plan that has been outlined.
But no follow-up of that plan to make sure that's
No.
happening? Should the court have that supervisory jurisdiction, or should there be a department mechanism to enable you to review those placements?
There's probably a number of potential solutions
Yes.
to that issue.
Yes.
The court being one, the department being another, albeit that the department no longer has legal responsibility, or funded or Aboriginal community-controlled organisations being provided with the capacity to undertake some of that functionality.
It's not just cultural safety, it's connection to culture, country and community. Just to clarify,
No,
it's not
accept
just
that.
cultural safety.
Cultural plan.
No,
Yeah.
accept that. Yeah.
So can you give us some examples of where a child might be placed under a permanent order?
The most typical pathway for children going into permanent care is through a conversion of an existing kinship placement or foster care placement.
Into a permanent
Into a
arrangement,
permanent
with,
arrangement.
with kin.
Correctly. Correct.
That could also include permanent placement to residential care, or they continue? No, they're
So
subject
it has to be a kinship carer, a foster carer, or a specifically recruited carer for that child. We don't permanently care into residential care settings.
So that could be a non-Aboriginal person or a person not related as by way of extended family to the child. It could be somebody not within the same community.
It could be, but remembering that the only way that a permanent care order can be issued is if the Children's Court is satisfied that a report from the Victorian Aboriginal Childcare Agency or another Aboriginal community-controlled organisation supports the making of that placement. If there is no support for the making of that placement, the placement cannot be made.
I understand. So the permanent order, and I think you've already answered this previously, to whoever that permanent order is, the care is placed, the care of the child is placed with that person or persons. The plan at the time of the order is then there is no follow-up.
No, there isn't.
So we can't ensure that children are connected to their siblings if they're placed separately, if they go on a permanent care order. We can't ensure that they're connected to country culture, like, we can't guarantee that.
Well, there is a capacity to have conditions on the permanent care order.
Who enforces those conditions?
The onus is on the permanent carers who take on that responsibility. And if there is non-compliance with the conditions, there is a capacity for birth parents to bring an application to the court.
How many times has that happened?
I'm not sure.
I would say that would probably be very rare, but there is no guarantee that once this child, I mean, anybody, let's be clear that these children will then be lost to culture, country, family, mob, if no one has oversight of making sure these orders, we're relying on goodwill, and probably their money spent on making sure these kids keep connected. Is that what is that it?
Well, the safeguard being, the predominant safeguard being that there is an assessment of suitability of that placement and the cultural suitability of that placement. Commissioner, it's the reason why we don't have a lot of Aboriginal children in permanent care. It is not considered the most appropriate cultural pathway for children.
No, it's not, but you've just said that there needs to be an assessment. So Aboriginal children are going into permanent care?
They are.
So they are?
Yep.
And so then once that order's made, and the order could say meeting with siblings this many times, making sure they're connected to this, this and this.
Yes.
And the cultural support plan, if it's done, that goes with it. And the ACO that's done the assessment that goes with it to say
Yes.
they don't even have to speak to anybody after that, do they? Once that order's made, they've got this child.
No, but you can envisage that many of these families would be receiving support from a number of Aboriginal community-controlled organisations. Now, that I'm not suggesting that means by receiving support that they would be monitoring the compliance.
So is there a permanent care program that carers can access if they're non-Aboriginal and have Aboriginal kids in their care?
If they're not...
If there's a non-Aboriginal carer
Yes.
and they become a permanent carer
Yes.
for an Aboriginal child, is there programs set up to support these non-Aboriginal carers?
I don't believe there is a specific program that's set up to support them.
Okay.
Is that a factor that is taken into account in consideration of the principle, best interests of the child, under section 10(1)(f), desirability of continuity and permanency?
Yes.
So when designing the report to the court recommending a permanent placement order, is it your evidence that child protection practitioners consider the ability to deliver, monitor, supervise, guarantee cultural plans over permanency, over the course of the permanent placement?
I think that's the input that we gain from an assessment of the cultural suitability and ability of the carers to comply with the cultural requirements for that child. And that input comes from an assessment that's undertaken by an Aboriginal community-controlled organisation and a report that is furnished to the court for its consideration.
Can I ask a question, please? Care permanency is different to adoption,
Yes.
and we're here talking about the subject of care permanency,
Yes.
which is what a family might achieve by an order of the children's court,
Through the issuing of a permanent care order.
or by that court,
By the court.
in
That's right.
proceedings to which you will be a party.
Yes.
And at the point that that order is made, the child has the human rights which we've earlier discussed, several of them,
Yep.
including the right to possession of, knowledge of, practice of, connection with culture.
Yes.
a permanency order can be cancelled or the conditions altered by the court.
Conditions could be varied, yes.
Yes, or the order could be cancelled by the court in circumstances.
I'd have to refresh my memory. I think there is a capacity for a revocation.
Revocation. And it's your responsibility to administer that aspect of the system, is it not? What's to happen post-permanency in circumstances where there might need to be a change of conditions or a revocation?
Yes, it is our responsibility for the administration of the system, but not to bring an application to court directly, because the department does not have any enduring responsibility once a permanent care order has been issued. So the carer or the birth parents could bring an application to vary or revoke,
I see.
but not the department. The department could be re-engaged because a permanent care placement breaks down, and then a report is made to the department to reinstigate investigations and undertake engagement with the family to identify the needs and make suitable arrangements.
You obviously consider, because you have conceded, that you have a responsibility towards the child with respect to the realisation of their human rights.
Yes.
It seems as if the system does not have a mechanism whereby you can exercise that responsibility for a child who's the subject of a permanent care order.
Yes, because it is a third-party order, one that is issued formally to an assessed, accredited permanent carer, and transfers parental responsibilities for that child to the permanent carer.
But that means you could be transferring a child by a permanent care order into a culturally unsafe environment, or one that becomes a culturally unsafe environment.
So, accept that that's possible, but it's
That's
mitigated.
assimilationist, isn't it?
I wouldn't characterise it in that way. It is mitigated by an assessment of cultural suitability that is undertaken by an Aboriginal community-controlled organisation, and the court has to have that
Yes.
before it determines the suitability of the permanent carers to take on the care, parental responsibilities of that child. I would not characterise it as assimilation.
Well, the background to this is that we have received testimony, call it what you will, from people who have lost, who have been in undercare with non-parents, who've lost culture in the way that Commissioner Hunter has referred to. And surely if the legal framework does not actually guarantee continuing access by the child to their own culture, the realisation of their human rights, then there's a danger that it can operate in an assimilationist fashion.
As I said, I think there are built-in mitigations to that.
Okay.
Without knowing the evidence that you've received, Commissioner, around the specifics of some of those situations, I want to be clear about whether it's in the realms of an issuing of a permanent carer, or if it predates that. So, but I agree, if it predates the process, then it is a different context. Again, I come back.
I'm talking about what you're describing as transfer of responsibility.
Yes.
And I think you've made it clear that you do consider that the safeguard is at the point of the making of the order.
Yes.
Because there is inquiry, and it's done on the certification.
That's right.
Of VACCHO, I think.
That's right. Yeah, that's right.
Can I just ask, is VACA the only one that does that permanent care
I
inquiry?
believe so.
And so have they all been in under VACA's management, or have they been with other organisations?
No, they can be across any organisation.
So that child, after, say, 2 to 5 years in care, and you're seeking, then you have to bring another worker in to come and assess from a different agency to assess that?
The suitability,
Yeah.
the cultural suitability of
Yeah.
that placement, yes, that's right.
Do
It's
you-
an independent assessment, if you like.
So they would do their own as well if there was a child under their care?
Yes.
Is that the same for, say, Section 18? They have that, who has that responsibility, or has that not been?
In relation to, when you reference Section 18,
So if they have a child under Section 18 that may go to permanent care, for instance?
oh yes, yeah,
What would,
that the requirement would be the same, that before the issuing of a permanent care order, an assessment of suitability of the placement would need to be provided to the Children's Court.
okay. Do you think if the Aboriginal child placement principle was followed, we'd have less children going, I don't know the number, Aboriginal children going into permanent care?
When you compare the pathways for children into permanent care, we have significantly less children going into permanent care because of some of the concerns about the suitability of those arrangements, the more enduring suitability of those arrangements, which is why we have more children captured in our data here in Victoria, because they generally remain on long-term care orders for a longer period of time. So they don't exit the system and they remain part of our count, which is why you get the numbers that we have in the state.
Well,
So when you sorry, Commissioner, but when you contrast the exit pathways between First Peoples children and non-First Peoples children, the pathway to permanency for non-First Peoples children is far greater. We transition more children into permanent care. By transitioning more children into permanent care, it has the effect of providing stability for those children. It also has the effect of taking those children off the numbers and the count of how many children remain in statutory care.
Can you give us some numbers on that so we can see the size of that difference,
Yeah,
please?
of course. The permanent care numbers for First Peoples children are 461.
In 12 months?
As of, and that's over financial year 21-22, just to be clear. Thank you for clarifying that. At the same time, for non-Aboriginal children, 3,000.
Okay, so percentage-wise, what's the percentage rather than the raw numbers?
I haven't got that percentage in front of me, but
We
yes,
can't
yes.
compare 491
No,
with
no,
3,000.
agree.
because they're
I just don't have that in front of me at the moment, but we can get that information. And
Sounds like an awful 491
Yes.
kids went into permanent care.
no, that's not entry. That's how many children are in permanent care as an average through that period of time. That's not entries, in total.
Over some years, potentially.
Yeah, some of them would have been
Okay.
there
The
for
whole-
years.
the whole
Yeah,
cohort.
Yeah,
So it's very hard for us to assess the difference.
the entry pathway. Yeah, so we can get that information if we haven't already provided. I suspect we have, but let's leave that for another time.
sorry, just one quick question. If you've got a child that goes on a permanent care order that's actually not First Nations from Victoria, how do we ensure that they're still connected to their mob in another state? Like, how do we ensure this is happening, that kids are connected? And I know there's a lot of kids
Yes.
in Victoria who are from
Yes, there are.
other states. So how do we keep them connected?
Yeah, and that's the cultural plan that sets the expectations about what carers are responsible for for undertaking, and those undertakings are conferred in the issuing of a permanent care order by the court, which has an expectation that they will fulfil those undertakings. The question you rightly point to is an extension. How do we monitor that? We don't have a monitoring mechanism.
If we had a monitoring mechanism, it would need to be a national mechanism. Agree?
Yes, that would be the ideal. Trying to get a national mechanism is incredibly challenging.
Well, children and their families don't stay put, we know that, and the borders are meaningless in terms of people's movement. So a national mechanism would be highly desirable, I suggest.
Yes, always. National consistency is always desirable, but I just want to reinforce for the Commission this issue about the numbers and the pathways, because it is an important issue, and feel free to interrogate it a little bit more if you're not clear.
The point you're making is that this is non-preferred from your point of view, and you always try and locate within an Aboriginal family.
That is one point. The other point is the exit pathways, creating an environment where more children are counted, more First Peoples children are counted in our overall numbers.
But to be fair, we actually need the numbers to
Yeah,
the veracity of that claim. It's
yes,
can't say that that's influencing the proportions.
yeah. No, and
Data.
we'll provide that data to you, Commissioner, but it does have the effect of increasing the number of First Peoples children that we have in our count compared to non-First Peoples children.
Sorry, I'm just going to go back to the Act, and you mentioned it, Ms McLeod, the child's voice and their rights of self-determination. Is that taken into account in that
Wishes of the
care?
child are taken into account, yes.
Even if they're under 10?
Yes.
But as I think we discussed yesterday, the wishes of the child are ascertained through a conversation rather than through any formal
In the
mechanism.
context of an application to the Children's Court,
Yes.
those wishes are ascertained through representatives of the child in those matters.
Where there's an independent child representative
Yes.
appointed.
Yes.
Can I come back to the Act just briefly to finish this off? And Division 4, Section 12.13.14, concerning additional decision-making principles for Aboriginal children. Under Section 12, I'm summarising here, the Secretary or a community service must offer an opportunity to members of the Aboriginal community and elders to contribute under subsection 12.1a, and should convene an Aboriginal family-led decision-making meeting with an Aboriginal convener and others under B if the child is placed in out-of-home care. And under C, in making a decision to place an Aboriginal child in out-of-home care, an Aboriginal agency must first be consulted and the Aboriginal child placement principle must be applied. Now that principle is then defined in Section 13 with the requirements of seeking advice of an Aboriginal agency, placement with family or other Aboriginal persons as required by subsection 2A through to C. Can you tell the Commission, stop for a minute, the Commissioner for Children and Young People has raised with us the following matters. Regrettably, she said there have been many occasions where an Aboriginal family-led decision-making process has not occurred when it should have. For example, a change in case plan from reunification to non-reunification, final orders being made which place a child in out-of-home care, conciliation conferences being adjourned because an AFL DM has not been conducted, and occasions where an AFL DM has been scheduled to take place after conclusion of a contested filing hearing. At all times when an Aboriginal child is in out-of-home care, and most critically, when the department has a non-reunification case plan, it is essential for AFDLMs to be conducted in a timely manner. not only in order for the court, the department and Aboriginal controlled organisations to be satisfied there's been compliance with the specific provisions relating to Aboriginal children, but also to ensure all possible inquiries have been made with family to explore whatever possibilities there may be for an Aboriginal child to live with family or for their family to have ongoing involvement in the child's life. We were referred to the Always Was or Always Will Be report and the review by the Commission of almost 1,000 of the children's cases between 2014 and 16. So that's a 2016 report, HB 1.0001.0002.0001, page 65, that found that 50% of cases, those 1,000 cases, had never had an AFL-DM meeting, and the report, in our own words, HB 1.0001.0002.0677, which found that the department instituted some changes in response to Always Was, Always Will Be, so this is in 2018, intended to strengthen compliance with AFL-DM meeting requirements. However, the Commission report notes improvements has been very gradual. At the end of 2018, 47% of Aboriginal children who'd been in out-of-home care had never had an AFL-DM meeting. So just bring us up to speed briefly, if you can, with the current rate of compliance, if you know it, and the importance of holding those family-led decision-making conferences as required by the Act.
There's a lot in that, Ms McLeod.
Yes, I apologise for racing, but take the time you need to break it down.
Can I start by saying there is, I'm sure I can check this, but my understanding is that the holding of an AFL-DM meeting is not a legislative requirement in itself. The consultation and engagement with an Aboriginal community-controlled organisation is what is intended through the provisions in the Act. That consultation comes in a number of different ways. We spoke yesterday about access being the primary mechanism for how we get cultural input into the decision-making of child protection. That is a primary mechanism.
So is it your evidence that Section 12 and 13 requirements to have family-led input into decisions is being met not just through those Aboriginal family-led decision-making meetings, but in other ways as well?
It is one, so yes, that's what I'm saying. It's suggesting that the mechanism of an Aboriginal family-led decision-making is one mechanism of input. It is an important mechanism for how we get Aboriginal families to provide input to those decisions.
I follow. And you probably have other things to say about this, but will the draft legislation that we've referred to coming before Parliament address or strengthen these principles of family-led decision-making?
It would...
Assuming they're passed.
Yes. So on the assumption that they are passed, there will be a strengthened expectation through the Statement of Recognition and the 10 binding principles, which we will now have to work through to operationalise and would have the effect of strengthening the provision of family decision-making and input, cultural input into decisions around First Peoples, children.
Are the 10 binding principles you referred to actually set out in the draft legislation?
They are.
And do they reflect the current? Sorry, do they reflect the current legislative requirements? Or
They
are they an
reflect
improvement?
and augment the current provisions.
Just, you mentioned access again. They're a specialist advice service.
Correct.
they're an advice and support service
they are.
to have the cultural input. So you don't advice and support, you don't have to actually take that on. You consult,
That's right.
is that right?
Yeah, that's right. And again, what I also mentioned yesterday was we are in transition. Back in the 1980s, we put access in place because there was nothing else that was providing that cultural attuned input into our assessment. As we transfer greater numbers of children to Aboriginal community controlled organisations, there is less of a requirement to do that because they are being looked after by Aboriginal community controlled organisations within community. So we're in transition is what I would say, and the aspiration being that all Aboriginal children will be managed, supported, looked after by an ACAC provider in the future. Subject.
But in the meantime, access is just
In the
an
meantime, it
advice
is.
and just support.
Yes,
Like
yes.
you don't, they've got no authority in the case, or they don't do case management.
No. The accountability for decision making still rests with the department.
Okay, thank you.
And just while I'm on the topic of the Commission's reports, Commissioner Singh noted that there were no specific legislative functions, powers or duties attributed to the Commissioner for Aboriginal Children and Young People, but she indicated in her evidence it would be useful to create a specific role. So mostly she works through the Commission generally and delegated powers or
Yes.
collaborative
Yes.
functions.
Yes.
She noted it would be useful for her commission, her role to be entrenched in the legislation. Does the department have a view about that?
I think it would be a consideration for the Commission, for this Commission as well. It would signify an important additional element of strength within the overall functioning of the Children and Young Persons Commission.
And finally, I wanted to touch on the requirement in section 14, further principles for placement of Aboriginal child, concerning self-identification and the expressed wishes of the child. The section requires, in determining where a child is to be placed, account is to be taken of whether the child identifies as Aboriginal and the expressed wishes of the child. So going back to this conversation about the rights of the child and ascertaining children's witnesses, is there anything directing the child protection practitioner to directly ask these two questions about identity and wishes?
Yes.
So the
And
materials direct them to specifically
Yes.
ask those questions?
yes, and in fact, over the last few years, we've strengthened those provisions and are ensuring that all children and their families are specifically asked to identify.
I wanted to leave the Act now. Is that a convenient time to break for lunch?
Yes. Sorry, Council.
Thank you, Commissioner. Should we come
Yes.
back in an hour or at 2 o'clock?
Well, it's 2 o'clock, it's 12:54, it's, yeah, 2 o'clock, I think.
Commissioner, please. I wanted to start this afternoon's consideration of a number of different topics and to ask you briefly about each of those topics. Certainly, if there's more to ask or more to say on those topics, we would welcome the department's follow-up contribution, either by way of a further statement or perhaps even getting you back. Okay. So can I start with the broad topic of risk assessment and the tools that those making decisions about placement and removal of children in the child protection system have to guide their decision-making? Yesterday we spoke briefly about a risk assessment matrix and the traditional way, if I can refer to risk assessment in a traditional way, where child protection workers are looking at risk factors, protective or control factors, measures in place to address those control factors, and then the matrix of likelihood of risk, likelihood of occurrence, and consequences, where they fit on the scale.
Yep.
So the first, sorry, I haven't touched on this, but the guiding document for all practitioners in the conduct of their work generally is the Child Protection Manual. Is that right?
That's right.
Now, that is an online manual that is continually reviewed,
It is.
and it's a lengthy document.
It is.
That is a document, no doubt, that workers have, if I can use that term without disparaging them, that workers become familiar with at induction,
Yes.
and that is their primary tool
It's the primary source
of information.
advice, policy, and practice guidance.
Okay. Now, the Child Protection Manual is intended to embed the legislative requirements
Yes,
to guide the conduct of the protection worker.
correct.
Okay. The complexity of the Child Protection Manual and the various suite of policies and guidelines that are available to a child protection worker was recognised by the department as being complex, and as a result, the department produced a safer children framework guide in October 2021. Is that right?
Can I clarify that?
Yes, please.
So it's not the Child Protection Manual per se. It was the reason why the department developed the safer child protection risk assessment was largely to give more precise guidance to practitioners beyond what the best interest case practice model was able to provide. The best interest case practice model was an overarching practice framework, and within that, practitioners had to, in a sense, find their way through the process of assessment, and sometimes it lacked critical direction in terms of elements of the assessment that practitioners should focus on.
The legislative underpinning, or one of the legislative underpinnings for this, is section 162 of the Act, which spells out, I don't need to take you to this, but it spells out, the heading is when is a child in need of protection?
Yes.
And it spells out various matters that must be considered,
Yes.
including death of a parent, physical or emotional harm, including sexual abuse, physical health and development,
Yes.
things of that nature. And harm is not further defined in the Act beyond that section, is it?
No, that's the primary referencing of physical, sexual and emotional harms.
You tell us in paragraph 297 of your statement that the process for deciding removal that is followed is a risk assessment using the Safer Children Risk Assessment Framework and consultation, as you've mentioned, with an access.
Yes.
You also say that it's only when the following factors are indicated within SAFER that there is a need to consider removing the child.
Yes.
And as I've just mentioned, the consequence of harm is rated as severe or significant.
Yep.
The probability of harm is considered very likely,
Yes.
and the child's safety needs cannot be met by the parents.
Yes.
Now, the SAFER document is this document I'm holding up here.
Yep.
Safer Children Framework Guide, the 5 practice activities of risk assessment in child protection, and we're particularly interested in, the A, which is for analysis, analyse information and evidence to determine the risk assessment. Right? That framework, just to circle back on my earlier questions, was rolled out in November 2021, in part in response to the deaths of a number of children. And I don't want you in any way to tread across the current work before the coroner in relation to the facts of that particular inquiry, but I do want to ask you about this statement that has been reported attributed to Ms. Kirsty Lomas. Now, she was formerly the Acting Executive Director of the Office of Professional Practice and Acting Chief Practitioner for the department, and has been described as the state's principal child protection practitioner for the department. As I said, I'm not interested in her evidence going to that particular matter, so if we can navigate that, just this safer guide. And she indicated, it's reported, what we sought to do here is to bring together something that's a bit complex for the busy work of child protection practitioners, which is, have they actually analysed and made sense of all the information that they have? We've broken it up into 3 elements: analysis, judgment, and then decisions. So that's a fair reflection of the process. I'm interested in what parts of this process are subjective or rely on what we could broadly call professional judgment. What is within the remit of discretion of the child protection practitioner? Okay. Now, before the introduction of the Safer Framework in 2021, she has publicly acknowledged that the process of sorting information was a bit complex for a busy child protection practitioner. So there were some challenges around that. The aim of this document is to simplify it, and I take it you'd agree with me that we must ensure there's consistency between the guidance document in SAFER and the legislative requirements. Yes. So in terms of what is now required of the analysis elements, she has also been reported as saying child protection practitioners found SAFER by and large positive. So there was some survey or evaluation of how child protection practitioners found it using these new tools conducted by the department? And that was essentially a survey of their opinions, was it?
Yes.
Did that survey reveal, because she used the word by and large, did that survey reveal which aspects were not positive?
I think the survey in general terms indicated a positive reflection from the workforce about the usability of the new risk assessment framework.
Yes.
Its application to the role and function of our practitioners, and the way that they would determine risk of harm.
So when she says by and large positive, obviously there were some aspects that were not positive. So it's that I'm interested in.
Right. Okay. I think one of the elements that the workforce alluded to was the level of preparation and support through the implementation process, which is an ongoing process as we continue to embed the new framework into the operational environment. So I think there was nothing from what I can recall that stood out as a critical issue for the workforce in terms of its application of the new framework. Generally, they found it a much more tangible risk assessment framework. It provides much more clarity and guidance to how they assemble information, undertake an analysis of that information to determine potential harm and any action that is required of them.
This framework, and I might ask that it be brought up on the screen, it's the Safer Children Framework Guide DFFH.0005.0001.0976. We have it on the screen at page .1007. Could we bring up page .1007, please? And I'll tell you what the equivalent page is on your hard copy. 1007. So this is page 24 of the hard copy report. At the foot of the page, you see a circle, a number of circles, figure 8, the seven essential information categories.
Yes.
They are harm, family violence, strengths, protection and safety, family, community, environment, individual child, parent or caregiver. Now, just with respect to the third highlighted circle there, strengths, there's no specific guidance in this SAFER document, is there, that requires that practitioner to consider the strength of culture as a protective factor.
Without having looked at every element of it, from what I can see here, not specifically, but what I can say is that there is additional guidance that is provided to practitioners through the best interest case practice practice guidance, where they are topic-based elements that practitioners use to inform their application of some of these essential information categories.
I'm interested in where the slippage might be occurring here. There's already a need to go beyond this document to look to topic-specific guidance material.
Yes.
The SAFER evaluation report of 2022 found there was limited use of the essential information categories, in particular strength, safety and protection, as a consideration in weighing up those 7 essential information categories. I ask you to accept that. Does that sound familiar to you?
It does.
So does a child protection practitioner, in practice, refer back to this guide in conducting the risk assessment and also have to look at the other guides and policies at the same time?
Yes, inevitably, because it is a mixture of a professional judgment assessment model that we have here that on its own cannot incorporate all elements of those 7 essential information categories, and it requires augmentation by additional sources of advice.
Right. So you've got this constant process of simplification to make things easier, but then adding back the complexity if you need to.
I wouldn't characterise it in that way.
How would you
I would characterise it as that those guides, particularly for newer practitioners, are there to orient and support the attention that they need to be given to how they work their way through a risk assessment process. Over time, and with practice experience, and with practice wisdom, those become embedded within the practice of a practitioner.
So when the evaluation gives you the feedback, as it did in last year,
Yes.
that there was a limited use of the essential information categories, in particular strengths
Yes.
and protection, which are critical to the assessment of
Yes.
whether a child is at risk or
Yes.
not and the decision that follows, how do you then ensure that practitioners pay sufficient attention to strengths and protection and safety, given that this document doesn't touch on those things?
It goes to the opportunities that emerge out of that survey, if you like, or evaluation, which talks to how we continue to embed the new framework into the operational environment, what additional training and support our practitioners will need, what additional implementation support they will need to be guided about the use of all elements of the essential information categories,
Okay, so
inclusive of those protective ones.
In essence, that's a work in progress.
That's work in progress. It's a relatively new framework that is continuing to be embedded into our operational environment.
Would it be useful, do you think, given the exchange with the commissioners before lunch, to embed in this document at some highlight feature the need to consider cultural safety and support?
Without having gone through every page of this, Ms McLeod, I would say that there are probably references already in here around protective factors, and culture being one of those protective factors. And if not, then yes, it would be absolutely useful for us to consider whether we need to incorporate more into this. But the other element would be that this is not a framework that stands on its own. This is a framework that is embedded within a suite of practice advice that practitioners are required to incorporate to assist them in being able to navigate through the child protection assessment process.
Plunky.
Just in the way that in relation to family violence, MARAM is incorporated
Yes.
in the framework, but
Yes.
also
That's the multi-agency risk assessment and management
that's right.
tool.
And there is specific guidance that is around the multi-agency risk assessment management tool. Now, not all of it is referenced in here. It might be referenced, but it cannot feasibly, you cannot feasibly incorporate all of those elements of advice in one document such as this.
That's why I'm asking about the success of simplification.
Yep.
And need to go beyond the simple document.
And that's
Getting the
why I'm
balance right
saying
there.
that you can't, it's not one or the other. It has to be both. It is a complex environment of how you determine risk and safety, and there are many considerations that have to be incorporated, and to simplify it all into one document would just not do it justice.
So the practitioner who's on the ground trying to work out what there is to do has this document, which is aimed to simplify the labyrinthine child protection manual, if I can...
I need to more accurately reflect that. It is providing a much more clearer, accurate, professional judgment model of assessment that is also augmented by practice guidance that is relevant to that assessment process.
So,
Again, I know we're trying to simplify everything, right?
well, I'm concerned that the simplification process might miss important...
No, and that's a relevant concern. But what we've sought to do is go from something that clearly our practitioners were saying was just not working right for them to something that is a more balanced approach of developing and implementing a clearer model for how that professional judgment is undertaken that gives direction to our practitioners.
And that they're now saying is by and large positive.
Now it's saying by and large positive, notwithstanding that we are still in the relative early days of embedding this into our system. And
I acknowledge you said
this significant change does not get embedded within a system overnight. It takes some significant period of time, and with iterative adjustments that we would have to make based on the feedback that we are receiving.
And hopefully the feedback of this commission.
Absolutely, and many others who inevitably look at our practice.
So could I ask that page ending 0990 be brought up, which is page 7 of the document. This is the fold-out page.
Yes.
while that's being brought out, you have the hard copy there in front of
I do.
you. So this is SAFER is the acronym for the document. A is the section we're talking about. Under the heading of A, practice, in this page 7 ready reckoner, if you like, there's no reference under A to analyse the harm of removal. I ask you to accept that, and no reference at all in the training manual to weigh up the harm of removal, and particularly for First Nations children. And I'll be corrected if I'm wrong. I don't need you to read every page at the moment, but those assisting you could correct me if I'm wrong about that. Okay? I just ask you to accept that. Or is there something you want to bring to my attention?
Is that page 7 on the
Page
screen?
7 of the hard copy document?
Is
No,
that-
it's page DFFH.0005.0001.0990, which is a fold-out page. So hopefully our crew have got it.
It's on my reading of that page. That's accurate, but again, I'm qualifying that I'm only reading that page.
Okay.
No, there's some-
We've got it now. Thank you. And I was asking you about A there for those following the documents on the screen. Having got that page, can we go forward a few pages now to .0997 under the heading Professional Judgment, which is at page 14 of the hard copy document. Now, under the heading Professional Judgment is stated, professional judgment is about how our people use knowledge, skills and experience, how they bring their values and wisdom, how they manage their emotions and use their reasoning skills. The guided component is the legislation, policy, procedures, practice, guidance and tools that help us do our work. Together they make up our approach, a guided professional judgment approach to practice risk assessment and risk management. Now, you would agree with me, I take it, that professional judgment involves subjective as well as objective decision-making.
Yes, probably.
Probably? Sorry, can you just clarify?
Um,
Yes or no?
yes.
Thank you.
You would accept that if training with regards to cultural awareness is cursory or missing completely, comprising of perhaps 1 or 2 short modules, and decisions are otherwise based on professional judgment, there is a risk of bias entering the decision-making.
I wouldn't characterise the training and support that we provide our practitioners as minimal, particularly when you factor the not just the formal training, but also the guidance that they receive from their senior practitioners and their supervising officers as well.
This document at page 16 talks expressly about reasoning skills, including intuition, a cognitive process that somehow produces an answer, solution or idea without the use of a conscious, logically defensible step-by-step process. There's reference to the manuals, which do not replace the work we do to think critically, consider widely and gather evidence to support assessments.
Can I just clarify,
Yes.
that intuitive element is sourced through Hammond 1996, so I assume there is an evidence base.
I'm not suggesting there's not.
Yeah.
All I'm asking you to accept is that there's a human element here,
course.
which is subjective.
Yes.
And that if child practitioners are not armed with the tools to guide that intuition adequately, then that intuitive process and that subjective analysis will be compromised. Do you accept that?
If I would accept that if it was not mitigated by a number of other structures of support and guidance that is provided to practitioners. So just to give you an example, if I recall my practice days, I would not ever be in a position to make a decision, even when I undertook an assessment process, to make that decision in isolation without a thorough process of checks and balances that stepped my rationale, my decision-making framework, the evidence that I have in support of that to my supervising officer for endorsement.
So today, I understand it was some time ago that you went through, but today, where is that step-by-step process recorded?
On the child protection file.
In what document?
In the client record.
So is there a template for the completion of those aspects?
I think there's probably a number of ways that gets recorded. It gets recorded in supervisory notes.
Yes.
It gets recorded formally in the CRIS electronic file.
Yes.
And I'm happy to provide more advice about this,
Okay.
Ms. McLeod, in terms of the mechanisms, the more specific mechanisms that we use to record the decision making
That might be a
process.
narrative of
Could be
notes.
both a narrative and a process of determining that you have followed a decision-making process. Happy to come back to you on
Is
that.
there a checkbox?
Yeah, that's what I'm not.
Yes.
Yeah, I need to check that.
All right,
Yeah.
thank you. Are the CRIS notes transparent to those representing children and families?
Sorry, how do you mean?
Those representing children and families before court processes, do they get to see the CRIS notes or just the report that's produced as a result of those CRIS
It's
notes?
the report that's produced to court with the evidence that
Which is a
accompany
summary or synthesis of what's in the CRIS notes?
Yes, it reflects the determination of how a practitioner arrived to a determination about significant harm.
So if a worker, for example, included in a report that they had a protection concern, that might be a synthesis of a number of factors that are not readily transparent to those representing families and children. Would you accept that?
So I would accept it to the extent that it then gets tested within the court environment.
You would hope, depending on time available to the magistrate, resourcing of those advocates and their ability to analyse the material.
Yes, and that is the role of the court.
And as we know, those courts are hammered by the caseload and have often very little time to deal with review of those matters.
Ms. McLeod, I would go back to our earlier conversation. Many systems are hammered. Our system, the court system.
Except the court system is the oversight system.
It is.
Right?
Yeah.
It must have time and ability to examine these synthesis reports, if I can use that term, not pejoratively, but the synthesis reports that are presented, so that those representing children and their families can draw attention to the magistrate and say, this assertion of protective concern, this assertion of cumulative harm, depends on a number of minor factors that wouldn't be a concern in an ordinary household, for example.
Yeah.
Right? Do you accept that?
Okay. I accept that. But I also add that when matters are before the court and they are examined, particularly matters which are contested,
Yes,
all of those elements are thoroughly tested.
in an ideal world.
My understanding is that they are tested.
And I asked the last time you actually went to court on one of these things.
It's probably been a while, but I can understand. I know from our practitioners and I know from our court advisory teams that there is a range of advice that is provided to practitioners on the decision-making thresholds, even before we get to the point of issuing a protection application, let alone what happens post that.
So that's obviously from their perspective. What about the position of those legal services, Jura, VALS and others, who are representing clients before the courts? Have they given you feedback they have adequate time and resources to prepare reports?
I have not got that feedback.
Right. Can I ask you to look at the next page, page 17, practice wisdom? This heading says, the knowledge and skills gained through experience in working with children, families and professionals, and insight into how this combines with other knowledge and wisdom, such as that gained from study, training and critical reflection, practice wisdom that somebody like yourself might have after 30 years or so, comes from many and varied experiences across different roles and work environments as well as life experience. It comes from doing something that provides a base to reflect and consider how that experience might inform current practice and decision making for a child and family. Examples of practice wisdom relevant to practitioners. Second dot point, culturally safe practices that come from working directly with Aboriginal families. So it's listed there as a positive in terms of practice wisdom of a practitioner, but it sounds like, apart from the induction process, there's no mechanism to ensure that your workers have the capacity to develop those culturally safe practices themselves.
I would
Unless
say,
they're working with clients directly. First
yes,
Nations.
and working with a number of cultural advisors who are embedded within our teams, as well as obviously the practice guidance specific to working with First Peoples families.
So if that knowledge resides with another person, the child protection practitioner is required to consult with that other person in order for them to learn about culturally safe practices.
They are consulting with those other persons on a regular basis, be it AXAs, be it AFLDM advisors, be it Aboriginal cultural advisors. That's the very purpose for why we have these positions and functions embedded within the program, to build our capability, to build our workforce's capability.
Just on this point, you say at paragraph 362, data is not collected on the seniority of staff, identified in table 1.1, Aboriginal cultural safety, Aboriginal cultural awareness and safety, beginning practice and so on. So,
sorry, what?
So at paragraph 362 of your statement, you say data is not collected on the seniority of staff, identified in table 1.1. And we're talking about there all of new employees, all managers, all staff, and so on. Would be, I'll wait till you get it up. Sorry to rush you.
Sorry, what paragraph was it again?
362.
Apologies, my iPad seems to be tiring.
No, that's okay. It's been a long day.
Yes.
You say data is not collected on the seniority of staff identified in the table above. The table is table 11, Community Operations and Practice Leadership Division, Child Protection Training Attendance. And it comes back to the point that we were discussing before the break,
Yes.
it would be important, would you agree, that you know or ensure that senior people within child protection are undertaking cultural awareness training and have
Yes.
that level of competence?
Yes.
Okay. Can I ask you to turn to page 44 of the document, which is .1027. Yeah. So this is still under the analyse section. Analyse dimension number 1, vulnerability. Do you see the heading on the top of that page?
Yes.
Figure 12 illustrates, this is about 2 paragraphs in, the weighing up of vulnerability and parental capacity. Age, development and functioning are important factors that may point to increased vulnerability of the child. And figure 12 sets out various boxes that assist the practitioner to determine vulnerability of the child and parental capacity. You see that?
I do.
One of those factors, for example, under the hand parental capacity or above the hand parental capacity to meet child needs, is parents attend some of the child's health appointments but miss more than they attend. So is there a consideration that weighs up their ability to make those appointments, or things like transport, other...
That would be explored within the context of engaging with parents and understanding circumstances. It's not to read that as a blanket, take it or leave it. There is a process of engagement with families. There is a process of eliciting information to understand the family's context, to understand the barriers to attending. It's not to say that there is a ticker box saying you've missed 3 appointments, so that's an automatic strike and off we go.
I follow. So this is an indicator or a signpost for a
Yes.
practitioner to consider things
Yeah.
with examples given.
Yes.
Okay. Can we now turn to... Oh, sorry. Oh, no, that's all right. I think we've covered that. Can I now turn to a document which is a DHS document about trauma. The number is BAL5.0001.0001.001. Have you got that? Is this one of those, this was obviously, because the heading is Human Services. Is this still current, this document, do you know?
I haven't got it in front of me, so...
Oh, I'm sorry.
Oh, sorry.
The screen may not assist you. Could we just get you
Yes,
a
no,
hard copy?
that's fine. No, yes.
You can see that?
I can see
Zoom
it.
in if you
no,
need
that's okay.
to.
Yeah.
This document is a Human Services document, so I wonder if it's still current. You might need to look at it to be able to answer that, but this was certainly a document produced, we're told, by Human Services in 2012.
Can I ask, Ms McLeod, if that's something that we've provided you with?
I'm told we found this online under the best interest,
Then it is current.
a current document. The heading is Child Development and Trauma, and if you look on the left-hand side, if we could zoom in, please, on the 4th dot point, which commences culture. Just highlight that dot point on the left-hand column. Thank you. Culture, family, home and community play an important role in children's development as they impact on a child's experiences and opportunity. Cultural groups are likely to have particular values, priorities and practices in child rearing that will influence children's development, learning of particular skills and behaviour. The development of children from some cultural backgrounds will vary from traditional developmental norms, which usually reflect an Anglo-Western perspective. So this document, you think, if I found it online or we found it online, hasn't been updated since 2012, would that be fair?
It may be. Hard for me to say
tell us
without.
if I'm wrong in the follow-up.
Yep, no worries.
As I understand it, this is one of those guidance documents on a
Yes.
particular topic
Yes,
that the practitioner using the SAFER manual and following the child protection manual can refer to for advice about childhood development and trauma.
yes,
So if we look at the right-hand column, down the bottom paragraph, it says, specific characteristics and behaviours are indicative only. Many specific developmental characteristics should be seen as flags of a child's behaviour, which may need to be looked at more closely. If a child is not meeting them, practitioners should refer to the best interest case practice model and relevant specialist practice resourcing. So there's reference to
Yes.
another set of documents. Over the page, the heading is some important points about development. This is point 0002. And I'll read this to you and ask you to accept this. The indicators of trauma listed in this resource should not become judgments about the particular child or family made in isolation from others who know the child and family well or from other sources of information. They're a useful alert. So that's the intention of this guide. And there's reference to the explosion of knowledge back in 2012 with regard to the detrimental impact of neglect and child abuse trauma. I'm going to jump ahead of the tech crew here and ask that page .0004 be brought up, which is page 4 of the document. A list of child and family risk factors on the left-hand column. First dot point is family violence, current or past. 9 dot points in, we have history of neglect or abuse, state care, child death or placement of child or siblings, and then experience of, a couple of dot points down from that, experience of intergenerational abuse and trauma. Do you see that?
yes,
So the document acknowledges that child and family risk factors that should be taken into account include state care and experience of intergenerational abuse and trauma.
yes,
A child practitioner who comes to an Aboriginal family, do they make assumptions subjectively or based on their knowledge and
they
understanding?
test.
So do they
Through the
ask,
process.
has your family been exposed to removal or has your family
Yes,
suffered
that's what they do.
intergenerational trauma?
The process of gathering the information is a process of engagement.
Okay.
It's a process of talking with families. It's a process of exploring history.
And
and
what I'm
context.
interested in is whether those factors, which are presented as risk factors, are entered into the decision on the risk side of the equation so that all or most Aboriginal children already start with a negative on the risk assessment scale.
No, I would say that there is a process of practitioners engaging with families to understand their context, their history, their environment, and to use some of these risk factors as guidance in terms of looking to determine whether a child is in need of protection.
But this document directs them to take into account as a risk factor on the risk side of the equation
Yes.
state care and experience of intergenerational abuse and trauma, does it not?
Yes, it does.
Yep. So in the subjective...
And this is not, just to be really clear, this is not guidance specific to First Peoples. This is generic guidance for
Well,
all. So
no,
when
the
we talk about intergenerational, in this context, when
Yes.
we're talking about intergenerational trauma, it is in this context, it is a generic term. There are generations of abuse and trauma impacts in community
Yes.
across the state.
Yes, that we know, and the Prime Minister, former Prime Minister, has specifically apologised about the impact of those practices and policies on First Nations people.
In relation to First Nations peoples, that's right. Yeah. What I'm saying is that this is generic information as opposed to more targeted guidance that relates to considerations that should be cultural considerations that should be applied in relation to First Peoples families.
Okay.
So if you go on, this is really, I don't even know how people make decisions, to be honest with you, the way we're going through this. I'm just totally confused. You've got that generic, but then do you have to go over if it's an Aboriginal and Torres Strait Islander child or First Nations child to somewhere else to look? Because as the councillors pointed out, if you've got intergenerational trauma on a generic, you know, from colonisation, we've all got that as Aboriginal people.
Yeah.
So I don't, you know, if someone doesn't go over to specific cultural advice for Aboriginal and Torres Strait Islander children, and they've just read that, then it becomes a risk factor, right?
So in the context of this hearings exploration, it is a step-by-step process that we're interrogating over the multiplicity of practice advice. In the context of practice, practitioners accumulate knowledge, guidance, and incorporate that knowledge and guidance over time through their practice and through both formal sources of input, such as these, informal sources of input derived from their senior practitioners and practice advisors. And over time, they become more proficient in the way that they integrate this knowledge.
Like a very mysterious process about how this competence is achieved. I mean, I'm a qualified social worker, and just listening to that, I think, my goodness, I would not be able to navigate that system to actually work out what I should be doing with what family, what risk factors to take into account, what were protective factors, where culture comes in.
No, you've said it's a long process. Sorry to interrupt. You have said it's a long. So if they deem the child at immediate risk and the child's removed, how long does this process take of the assessment to decide if they stay in care or... Because that's trauma in itself, removing that child. Is that taken into consideration?
Yes, it is. As is the capacity to find suitable placements for children. All of those factors are considered. I think, Commissioner Walter, it goes to the complexity of...
I've heard that word a lot, and if I was a practitioner charged with taking children away from their families or not, I would not be comforted by the idea that it was really complex. I would be wanting to be really clear, if I was making a decision to remove a child, that it was absolutely the right decision, not that there was complexity.
So again, I challenge the Commission to grapple with this issue of complexity, because complexity is not going to be eliminated. And yes, you can put layers and layers of instruction in there, but that will not eliminate the complexity. And our services, whether it's our statutory child protection services or our Aboriginal community-controlled services, are dealing with the same level of complexity and having to grapple with risk and safety and protective factors as they make determinations about how they manage both removal of children but also reunification of children. Because that same process has to be determined when we're reunifying children. And then when we do reunify, as I said yesterday, and we're monitoring that process, those ACAC providers are going to have to make judgments about how safe is a placement.
They need to follow that. Do they need to follow that safer? Is that what they have to follow?
So there's a combination of approaches. Safer is being used largely by the Statutory Child Protection Service. BDAC is following Safer. VACA has got an adaptation in terms of the assessment framework that is being worked through.
Does the department have to approve that?
The department works closely with VACA in relation to the calibration of their assessment. And we've got an interest in that from the perspective of if there are ways where we can enhance the cultural elements of a child protection assessment, then of course we are always looking at ways that we can improve that approach.
Just on the handing over of say, investigations to whichever community-controlled organisations
Yes.
take them up, does everything stay the same and you just, like, there you go? Or is there, it does? Do you think that's fit for purpose for ACCO?
So the provisions that are incorporated in the bill that's before Parliament at the moment extends the transfer of authorisation through Section 18 to particular functions of investigation. The legislative framework is not changed, but through the consideration of this commission, it might be something that you want to consider about what a future system should be guided by from a legislative perspective.
What have you heard from ACCOs? Have they said anything around, because we're talking about building trust, right? And
Yes.
we're talking about building trust with our families, with our ACCOs, with the community. And to me, that's only done through not just listening, but action.
Yes.
So we've heard some evidence around, things about changing legislation, but it doesn't seem to be that it's going to be in that new bill coming through.
No. So I need to be really clear. This is significant incremental reform within the context of our existing legislative framework. So the Children, Youth and Families Act continues to be in operation. It continues to be the guiding legislation for all child protection activity across the state. Should that change in the future, and should different consideration be applied about what is a more fit-for-purpose legal framework, then that will be a very different context.
But you want to hand over to Aboriginal community-controlled organisations what we've already got and say...
We can only hand over within the context of the existing legislative
So I don't
provision.
see how it's working at the moment. It's not working because the overrepresentation of Aboriginal and Torres Strait Islander children in Victoria in care, and you're going to hand that same model over to community to do, you're going to get the same outcomes. Like, it's the same ingredients in a cake. You're just not asking them to cook it differently. Does it?
Well, I think we actually are, and by the very nature of how Aboriginal community-controlled organisations engage and the considerations that they bring to the work and the cultural elements that they bring to work and the level of trust that they bring to the work with families, I think they are all significantly different aspects of work with First Peoples families than what we have within the context of a Anglo child protection system.
So with ACAC at the moment, it's been going a while, what learnings has the department had and started to implement? Because you've said it's great things happening. Have you taken those learnings? And
essentially, it's all of those elements that I've just walked through. It's the level of trust that families have of ACCOs. It's the level of engagement that they are able to achieve, genuine engagement in a way that is underpinned by trust because they have members of their community working with them. It's the freeing up and more free-flowing elicitation of information from those families that means that they can work differently with a strong cultural lens to determine risk and safety. These are all critical elements.
use a term, but with the same white legislation, yeah?
Yeah, the legislation has not changed. The approach and the implementation is different when it is delivered through an Aboriginal cultural lens.
I think that's an incredible load to place on Aboriginal organisations to somehow use exactly the same legislation and processes and this multi-layered thing that's being and there is a hope, therefore, that somehow Aboriginal organisations are going to be able to get different outcomes from the same recipe. And I just think it's really unfair to be positioning Aboriginal controlled organisations with this expectation from the state when the department has not been able to deliver the change that you're now loading onto them to deliver
Well-
with the same legislation. It just seems really unfair.
I'd say a couple of things to that, Commissioner Walter. Aboriginal community-controlled organisations, many of them, not all of them, many of them, see the value in this and have provided us clear advice that that is the direction that they want us to go in, within the confines and constraints of the current legislative framework. This jurisdiction, Victoria, is the most progressive jurisdiction as it pertains to transfer of decision making. Other jurisdictions, Queensland notably, have recently begun that journey. New South Wales, about to begin that journey. It is accepted that this is a critical reform to move us forward and to move us closer to an Aboriginal-led system. It won't get us to a fully self-determined system. But the considerations of you as commissioners and this commissioner and this commission should turn its mind to what it would take to have a fully self-determined system. But we are on a journey and we are progressing that journey.
And so we should be with the rate of removal, the highest rates in the country, and only having whatever percentage it was cultural support plans as well. So it should be.
Can I ask a question about the reverse learning, which is that you've expressed confidence in the Aboriginal controlled or Aboriginal operated
Yes.
system at the moment, taking the point that it's the same system but it works better
Yes.
when Aboriginal people are in control of it
Yes.
and administer the system. Doesn't that say something about the inadequacy of the present system?
Yes.
Can you tell me what you think that is? What is the inadequacy of the present system?
I think I've said this, Commissioner Bell, a number of times, and it's in my statement.
Yes.
That the colonial underpinnings of our existing system continue to cast a dark shadow over our existing system. It is fundamentally drawn from those colonial days and impacts.
Yes.
And we have not shifted our legislative framework since those days. So they are deeply rooted into the system. Now, at some point, through the process of treaty, through the process of truth and justice tallying, and through the process of work of this commission, we might arrive at a different place about what a future system ought to look like for First Peoples in this state.
Well, that's a very generalised answer, and I accept the force of it at that level of generality. But speaking entirely for myself, I feel ashamed. I feel personally ashamed that non-Aboriginal people operating the same law don't deliver outcomes that are comparable.
Yes.
Now, I absolutely support a self-determining system.
Yes.
Absolutely support transfer. But I think we, non-Aboriginal people and you in management of the system, need to reflect on why.
Yes.
Because it is unsatisfactory.
Agree.
It is discriminatory. It violates human rights.
Agree.
Would you agree that we cannot have a system handed over to the control of Aboriginal controlled organisations that sets them up to fail?
I would absolutely agree with that.
So we have to do whatever is possible, we being the department and the state, we as citizens of the state have to do whatever is possible to get this system perfect as we can before that transfer
I think
occurs.
I've been on the record of saying that we are navigating through an orderly transition and not handballing these services to community-controlled organisations who either are not wishing to undertake these functions or who feel unprepared to undertake these functions. And as we have been working over the last decade, incrementally supporting our Aboriginal community-controlled organisations to build capability, to build confidence, and to build community acceptance that they wish to undertake this, any function across the continuum of care and support that we provide. And we know through the work that we've done, engaging deeply with our Aboriginal community-controlled organisations, that there are different perspectives and different views about how much they want to do and at what end of the spectrum and continuum they want to be focused on. And we've got to work and respect that.
And we cannot, the state, cannot kick that conversation and that readiness down to a treaty negotiation in a year or 2 or 3, can we?
And we will not. That's why we are not stopping the work, notwithstanding, rightly put, that the work that we are doing within the construct of an existing legal framework.
I'm moving very slowly.
Can I
Very
ask?
slowly.
Sorry, Commissioner.
Just saying, and it's moving very slowly.
And Commissioner, some would say when we seek to move faster in that direction, that we are overstepping our mark, and we should respect community in terms of their desire to be undertaking some of this work. And that's only in that context.
That's because you're transitioning the same model that is currently being implemented, there's no innovation in that. You're literally just handballing the same model to these Aboriginal community-controlled organisations.
Yes, we're working within
That's why you're getting the conservatism around the risk from their point.
I accept that, totally.
They've got to be also, they don't want all the red tape and no response. They don't want to be hamstrung by solely just red tape as well. And I think that's what government does really well to our communities, is handball, some resources, but the red tape then sits with them, and then they're accountable to everyone.
Yep, I accept that. I accept that. And this is why we are at such a pivotal point and a unique opportunity that we have before us to drive a very different future system design.
Can I just finish off this topic by bringing up the Safer Risk Assessment Snapshot, DFFS.0005.0001.0974, and ask you whether you've got a hard or soft copy of that in front of you. It's on the screen.
But I can see it on.
You can see it on the screen. Yeah. So, as I understand it, this is one of the tools that was designed as part of the Safer package to reduce,
yes,
to make things a bit less complex, to use Ms Lamas's words, in navigating the system. Is this a live document, do you know?
It is a document that is on our system, yes.
Now, the practitioner, I assume, fills in the blank boxes next to each or below each question, and is there an ability to fill in as many words as required? Do you know your way around this form? I should have asked first.
Not specifically. I haven't worked my way through that, but I understand that there is a capacity to fill in as much detail as possible.
Okay, so you could write 1,000 words if you needed to below question 1, vulnerability of the
I'm sure
child.
I'll get some advice about what the limit of words are.
Okay. And this document was part of the deliberate design of simplifying the system or making it easier for practitioners to navigate. Is that fair?
Yes.
Is this document printed and found or saved in a soft copy version of the client file in each case?
I would expect so.
There's a reference to child's name and CRIS number up the top of the page. So is this a document that they must fill out when they're completing their assessment?
Yes, I expect so.
Okay. This is a 2-page document which is generic to all child protection decisions. It's not particular to First Nations.
That's right.
And likewise, there's no reference to First Nations connection to culture or other safety protective measures here.
There are references to the child's family context.
Yes.
Including their culture. So number one, who's the child in the context of their family, culture and community?
Yes, thank you for that, for drawing that to my attention. but that's assessed as a vulnerability factor, not as a safety or protective measure. Agree?
Yes.
So the child, who the child is in the context of their family, culture and community might include those trauma dot points that we went to in the DHS document, intergenerational trauma and family member in state care. So just stepping through it, the child practitioner fills in these boxes. So for box 1, we might see, for example, the child's age, fact of a family violence report, notes about parental circumstances, things of that nature.
Yes.
Any perceived compromise of the ability of the parent to care for the child. Those sort of things.
Yes.
And as you said, they can take as much space as they like in filling out that document.
Yes.
Is this just a summary of the information that goes into the
Yes.
CRIS system? Right. There's no reference in this tool itself to the objects of the Act or the guiding principles beyond the
Not in the
synthesis
tool.
that's reproduced.
That's right.
Here.
Yeah.
Okay. There's no place to note specifically specific services that might be provided by the state or an ECHO or the family, extended family, to defray risk.
I think under the safety quadrant is probably where you would get some of that.
That's intended to prompt a consideration of those factors.
Yes.
Okay. And is that also the place, or is it under vulnerability, likelihood of harm or severity of harm, that the practitioner considers the immediate and longer impact of removal of itself?
I think it's both under vulnerability and severity of harm.
So under vulnerability, when the practitioner is considering the context of the child in the context of their family, culture and community, the practitioner needs to think about the negative impact and longitudinal impacts of removal.
That is one of the considerations.
Well, it's definitely one of the considerations, but it's not prompted there, is it?
Not specifically.
Okay.
But again, this is a summary form, and what sits behind it is advice that emanates from this document and other practice guides.
And obviously the Commission is interested in the adequate signposts
Yes.
for that
Yes.
and the way that the practitioner navigates their thinking about these risk factors.
Yes.
The Marram assessment is referred to on the next page under judgment, where we have consequence of harm, probability of harm, and a risk rating for a child you bring together vulnerability of the child, which is risk, severity of harm, to form a conclusion about consequence and probability using the Marram model. You agree?
Yes.
And then you get to the decision box. Decisions are made as a result of the relationship between the two, and that's where you get your end result. So just so I understand it, this document's just intended to record that process, or is it intended
Yes.
to guide the practitioner through that process, or both?
Or both.
Has the department considered ways that that document and the guidance for practitioners might be improved?
It will be part of the ongoing evaluation of the risk assessment framework.
Okay. And on ordinary timelines, this is April last year, so only a year old, what would be the timeline for ordinary review of the application of this document?
Well, it's not just the document, just to be clear, it's about the
Whole
whole
framework?
risk assessment framework.
Would that be next year, this year?
I understand that there is current work to determine what the next evaluation phase of SAFER will be. I haven't got that in front of me at the moment.
Okay. I should have asked if the Commission wants to take a short break. I am sort of belting through things, but
I just ask one question about learning from ACCOs. And if I remember correctly, when Section 18 started, that there was a new template that VACA come up with around court reports. And that I remember it being the magistrates there because it was based on human rights and strengths of families. Has the department ever thought about adopting those types of reports to the...
I understand there have been changes to the court report formats that have been made over the last few years. Quite significant changes that have incorporated a range of inputs, including the input that has come from the Victorian Aboriginal Childcare Centre.
I just, from what Commissioner Bell was asking earlier,
Yes.
around the rights, basically the rights of the child, and you've got the Victorian Charter, you've got all these, and I know that was, and it showed strengths. That's how you try and
Yes.
gain trust, right?
Yes.
But I'd
Yes.
ask if that was taken on board at all.
Happy to have a closer look at that.
I gather the commissioners want to press on.
I think so. Is that okay? Yes.
Yeah.
Are you
Yeah,
happy
yes.
to press on?
Sure.
The end is in sight.
Can I ask whether
Yes.
there's any proposal to amend SAFER and the ancillary documents in the light of the recognition bill?
Yes, there will be. There will be a significant body of work that goes to implementing both the decision-making principles as well as the broader Aboriginal child placement principles once they get enacted into law.
This is not something that I previously considered, so it is
Yes.
very much a question.
Yes.
And the question is whether you've considered whether it's appropriate to have a comprehensive SAFER for all cases, or rather one that is specifically
Specific one.
targeted to First Peoples communities.
Yeah, I think it's a good question, and one that we will reflect on, particularly given the passage of the bill through
The bill,
Parliament.
yes.
Gives us I think a unique opportunity to re-look at how we strengthen our assessment frameworks in relation to First Peoples.
My listening to you respond to questions from council about the application of the current generic SAFER with respect to First Peoples families,
Yes.
suggested to me that it didn't capture adequately the strength and difference of the relationship
Yes.
between Aboriginal children and their family and
Yes.
kin, emphasis on kin, or their relationship with country, or their relationship with other aspects of their own community. Would you
yeah,
accept that?
I accept that, and would also say that whilst we've got some practice guidance that goes to how practitioners should approach their engagement with First Peoples, I recognise it's probably not deeply embedded within the construct of this framework.
Well, it's certainly not specifically picked up.
Yeah.
That's a problem, I would think. And it seems to me very likely that the reason why the system works so much better, even at this early stage, when administered by Aboriginal organisations, is that they bring that perspective naturally to bear.
They do. Agree.
Can I just ask more broadly on the sort of connection, culture and country in particular for Victorian Aboriginal children who have direct ties to Victoria, not someone
Yes.
from Queensland living in
Yes.
Victoria. What's the relationships department with the registered Aboriginal parties throughout Victoria? Because we've heard a lot about, obviously, ACCOs and the primary role that they play in this
Yes.
space, or they undertake in this place. But what about the role of traditional owner groups in this work? Because we hardly see it referenced. I see it in your acknowledging
Yes.
traditional
Yes.
owners, and then throughout the doc,
Yes.
the statement, sorry, it's pretty light on.
Yeah,
Yeah.
I think it's a fair comment, Commissioner. I think we largely reference those funded Aboriginal community-controlled organisations because they are they are the primary organisations within the orbit of our work, but that's not to say that broader connection to other parts of culture and connection to land is not undertaken. If I think about a whole range of cultural experiences that children and young people experience, they are instigated and put in place through those traditional owner groups as well. And both ACOs and traditional owner groups work closely together to bring some of that cultural perspective to children and young people in particular.
So do you, in your experience or knowledge, do you think that the traditional owner groups have involvement in the development of that cultural plan?
Probably not as much as we would want them to be.
They're the primary, culture is
Yes,
derived
yeah,
from those
accept
traditional
that,
owner
yes.
groups' place.
Yeah, I think there is definitely more that we can do in that space.
Can I just ask, I'm just looking at this thing and sort of saying, well, you're saying what's implied and it's implicit and it's there, but in actual fact, it's absent, isn't it? The specific recognition and reference to guide practitioners to consider First Peoples' specific conditions in this form. Why on earth would you, knowing the level of overrepresentation, why on earth would a form be designed like this that actually doesn't refer specifically to First Peoples' considerations?
I would go back to my previous comments about there is more detailed guidance, cultural guidance, that is provided through other documents that are meant to support this.
Know to go there, whereas it should, I would have thought it should have been
Sure.
front and centre.
Yeah, I take your point, Commissioner Walter. Yep.
And not just on the document, but listed as a strength or a protective or control factor. Agree?
Yes, potentially.
Whereas culture at the moment is in the risk
Potentially.
box.
Potentially, yes or no? You said potentially.
Did I?
Yes.
Apologies. It is
I'm listening.
getting late in the day. Apologies.
So yes,
Yes.
thank you.
Sorry, Ms McCall, just back to that, the risk assessment. We talk about intergenerational trauma. I get it, we just generally talk about it as an issue or could be a risk factor. We know it's high in our families, in First Nations families. What about intergenerational poverty or poverty? Where's that? Because we know our families struggle. Is that seen as risk, as neglect?
No.
Or how does that come into the risk factors?
Not on its own. We know that there are many families that are disadvantaged financially. On its own, that is not a risk factor. There has got to be a determination of harm to the child. So no, I would not say that disadvantage on its own is a risk factor.
Would you agree that ACOs do it better because they support the whole of the family?
Yes,
So isn't that a learning?
absolutely. It's why we've taken the direction that we're taking to transfer more capacity to our ACOs.
So if
It
you,
is a clear learning. It is a learning that we've arrived at through deep engagement and understanding of the impact of Aboriginal-led services to First Peoples.
there's some learnings out of that for the department, am I correct? That you could probably,
Absolutely.
yep.
And our practice has and will need to continue to change and evolve based on that learning.
You say that, rightly so, Aboriginal community-controlled organisations do it better than the department, have better outcomes for our kids. So what are the numbers of children eligible for Aboriginal guardianship currently? And how many are actually under guardianship with ACOs?
We've got just less than just shy of 200 children and young people who are under the guardianship.
How many would be eligible for that guardianship?
Look, I can get you that.
Would be a big number?
It'll be much bigger. We've got funded capacity to take us to about 400 children by 2024.
Then you're going to have more kids in care. And so you'd want to... What is it... If you know that children under Aboriginal guardianship, works, why aren't we moving that along?
Because we've got to go at the pace of Aboriginal community-controlled organisations.
Well, we know
But
two
they-
organisations that are currently doing it, and they've done their as if and
Yes.
is it funding or is it capacity?
We've got funding capacity to go up to 400, but the process is slow because we have to go at the pace of those community-controlled organisations in order that they feel comfortable, confident, and able to take on additional children. And as we progressively work our way through, not just the two that are delivering now, the others who are in pre-delivery phase, we will scale up that capacity.
How many Aboriginal children are in care all up?
2,600.
Okay. We might ask the organisations, see if they can respond to that, I think, at some point. Yep.
Can I just ask a question on, going back to the issue of the of safer covering all cases, do you understand the human rights concept of indirect discrimination? To treat different people the same
Yes.
might be formally equal, but in its operation, substantively,
Yes.
it's unequal.
Yes.
Do you understand that? And Aboriginal people, the First Peoples of Victoria, have unique social, cultural, family attributes you would accept.
I do.
It may be that SAFER operates in a manner that is indirectly discriminatory because of its failure to capture specifically those attributes. Would you care to comment on that?
I would say that in absence of looking at the practice guidance that provides the input to our practitioners, yes, you could say that, but you have to look at the holistic elements that are brought to the practitioner's knowledge base as they work through SAFER. It's not just that pro forma.
More to know, you say.
That's right.
Yes, okay, thank you.
I might segue from that conversation into the topic of kinship care. So we can take down that document, please, and ask that the document, the Victorian Auditor General's Office Kinship Care Report 2022 be brought up, BAL 5.0001.0001.1693, tab 10 in the bundle. And while that is being brought up, kinship care is the preferred and increasingly relied upon model of care where care is provided by a relative or a member of the child's extended social network.
Yes.
And there is a preference and a dependence on kinship care, particularly for First Nations children. Is that fair?
Yes.
Bringing up that kinship care document, could we turn please to page 1677 or page 6th page of the document, which is actually numbered 1, just to make life confusing, .1698. Make sure you've got that document in front of you.
I have.
Thank you. Alisandratos, the audit snapshot I'm looking at, and the box at the foot of the page under the heading Key Facts. So it's page number 1, but it's about 6 pages in. I just want to take you briefly through the criticisms of the Auditor General's report. And before I do that, you would acknowledge, in terms of the application of the best interest principle and the legislative requirements of the Act, the human rights considerations in terms of protective concerns of the child, and in practice best possible outcomes for children, that kinship care is very high up on the hierarchy of preferred placement options if family and immediate family are not available. Would you agree with that?
Yes, indeed, and reflected by the fact that we've got 79% of the children placed in kinship care arrangements.
Right, thank you. That's the current number?
It's a current number.
Okay. If we can look at those key facts, Part A assessments, what are they? That's the check if a placement is safe and can meet the child's needs.
Yes, that's right.
The target of the department is within 1 week of placement,
Yes,
but only 14.2% of placements meet that target. Part B assessments, assessing what support the carer needs to provide a safe, secure and nurturing home. The target is 6 weeks of placement.
yes.
Only 2.2% meet that target. So just pausing there, does that mean a child can be placed with a kinship carer and it's longer than, for 98 or so % of cases, it's longer than 6 weeks before anybody confirms what that kinship carer needs to provide a safe, secure and nurturing home?
So I would say that, yes, in a formal sense of capturing that information in a report, and it's a formalised assessment report. That doesn't mean that through the engagement with carers that we are not determining needs and actioning some of those needs.
Okay, so what's the relevance of the report as the trigger for this data point? Is that a report to the court or is that a report?
No, it's an actual assessment report that needs to be completed by a practitioner, be it a statutory child protection practitioner
I see.
or a funded organisational practitioner.
So they're missing that deadline in 98% of cases.
They're missing the deadline of completing
The report.
that report, that
98%
formal
cases.
assessment. That's right.
And so do you know, underlying that, in how many cases they are missing the deadline for the actual assessment of what's needed by that kinship carer?
No, it's difficult for me to say that, but having said that, we know that through the process of engagement with kinship carers, either at the point of placement, initial point of placement, or through the early phases of that placement, there are conversations around what needs a particular carer might have.
We've heard evidence in the Commission of family members, grandmothers for example, taking on the care of
Yes.
grandchildren in addition to other family members that they have caring responsibility for,
Yes.
and not having the wherewithal to transport them to school, to manage the additional requirements of an extended family, which then obviously impact on the child's ability to access education, health, and all those other
Yes.
important aspects.
Yes.
So these reports, I assume, are critical, a critical way to measure the delivery of support services. Would
Yes.
you agree? Yeah. Okay.
Yes.
The next factor is Part C assessments. Check the child's progress, wellbeing and development and the placement stability. Those are to be conducted annually, but at the time of this assessment, less than 1% met the target.
Yes.
You want to say anything about that?
No.
And in terms of kinship carers' allowance rate, 96% of kinship carers receive the lowest level of care allowance compared to 32% of foster carers, which I take it you'd agree places a very significant burden on those who are asked to take up kinship care for family members.
Yes.
I'll just touch on the other criticisms and then ask you to respond globally, if you don't mind. At page... Oh, sorry, I should ask you now so that you don't forget them all. Is there anything else you want to say about those findings by the Auditor-General?
Only that the Department has accepted both findings and recommendations outlined by the Auditor-General.
I'm sorry, did you say they are the findings of the Auditor General?
No, the department has accepted
Accepted.
findings and recommendation and all recommendations made by the Auditor General in respect to this audit.
Okay, now this is a relatively recent report, 21-22.
Yes.
So what is the timeline for implementing those recommendations?
I don't have that in front of me at the moment, but there will be an implementation approach to each and every one of those recommendations.
And is the Auditor General going to circle back and check
Yes, they
on your
will.
compliance with the...
Yes, they will.
Okay. So I can short-circuit this then. There are a number of recommendations within this report that relate to failures of the kinship care system and failures of the key performance measures around that system. Do you accept that generally?
Yes.
And all of those feed into the work to be done by the department to meet
Indeed.
those things. One of the aspects of that I just touched on is the inequity or disparity of payments to kinship carers compared to foster carers. And as I understand the evidence, that is largely because kinship carers do not understand or are not supported to access increases in their payments. Is that a fair summary of the findings?
Yes, that is one of the elements.
Why do you not just have one rate for kinship and foster carers?
It relates to the way that we engage, the different pathways of engagement
Well, the
between
base
kinship
rate's
care.
the same, is it not?
The base rate. So I should say that the 5 carer allowance payment categories are consistent for all carers. The application varies. The process of application for determining a carer allowance varies between foster care and kinship care. Foster care largely because those carers are recruited specifically to undertake the provision of care and go through an accreditation and assessment framework and are supported by community service organisations. Kinship carers largely are engaged at the point where child protection seeks to place a child in an alternative care setting. And so they do not go through a formal accreditation training process. The negotiation around carer allowance is determined through an assessment of need for the individual children in kinship care, and there is a process for how that need, where it's additional, gets reflected into a higher carer allowance. You're right, often carers find that process difficult, and because the large proportion of kinship care placements are managed by child protection, historically we haven't undertaken and paid the right attention to that. More recently, we have now funded and implemented a carer support help desk that will provide some additional support to how we determine the appropriate carer allowance for kinship carers.
And that help desk is intended to guide and assist the navigation of those kinship carer payments.
Yeah, the combination of the practitioner, either a statutory child protection practitioner or a funded community service organisation practitioner,
Yes.
and the carer support help desk is intended to support carers.
And is it the child protection practitioner who sets the allowance in the first place based on their assessment of need, supports and need?
It is, in the kinship care context,
Yes.
it is, the starting point is at the general rate, the first level, and then depending on the assessment of need with respect to the children and the carer's context, then a determination gets made about what additional carer allowance is required.
I understand that you're coming at this from different systems, if you like, for foster care and kinship
Yes.
care in terms of the vetting process for foster carers.
Yes.
Is there some way to ensure equity in the system so that the burden is not placed on kinship carers
Yeah,
financially?
we will be looking at this issue in terms of how we get more suitable support to kinship carers. It's not in anyone's interest, especially children who are placed in those settings and carers, for them to not feel financially supported to undertake the care that they've agreed to provide.
Particularly when you take into account that those kinship carers may themselves be carrying a burden of
Yes, indeed.
intergenerational trauma
Yes, indeed.
and other compromised social determinants.
Indeed.
With the kinship carer and the payments, so you've got the foster carer who could potentially be a non-Aboriginal person for an Aboriginal child, who'll have to follow a cultural support plan. So that goes for the same with the kinship carer. It could be the non-Aboriginal side of the family,
Yes.
and they would still have a cultural support plan,
Yes.
yet they may be funded differently to care for the child, one, and the
Potentially,
complexities.
yes.
Is that any of that taken into consideration around keeping the connection of the child in kinship care with non-Aboriginal family with the Aboriginal side of the family? Is that a factor in anything?
Is it a factor in...
Well, we've got a child in care that has one Aboriginal parent,
Yes.
but it goes to the non-Aboriginal side of the family.
Yes.
How is that maintained, that
Connection.
cultural right and connection?
Yeah, and that's through the earlier conversation we were having around contact provision and cultural planning that ought to bring those elements of how we maintain connection with the child's culture.
Does a kinship placement sit under a normal, sort of, say normal, a child protection worker? And do they...
A combination. There are kinship care placements that are supported by funded community service organisations, but the bulk of kinship care placements sit within the child protection program.
Thank you.
Commissioner Hunter's question with which you agreed was that for the same child, Aboriginal family kin get less than non-Aboriginal family kin. Do I understand you correctly that is how it
No,
works?
I wouldn't characterise it in that way.
Mhm.
If you're talking, so if a child is in foster care,
Mhm.
the allowance is determined through a formal mechanism of determining need for that child and assigning a carer allowance. There's a formal mechanism that is negotiated for foster carers, be it First Peoples foster carers or others. In the kinship care environment, the commencement is always at the general level, and then the negotiated process is undertaken through an assessment that the child protection practitioner undertakes with that carer family to determine what the allowance should look like.
We've got the figure here that 98%
Yes.
are not being assessed within 6 weeks. So, and we have heard evidence of people being severely placed under incredible financial and other constraints by taking their family in and then left with inadequate housing, inadequate transport, inability to move a child because they don't have childcare
Yes,
seats, all of those things. And we have this extraordinary figure of 98% not being assessed within 6 weeks. I'm gobsmacked.
Just before I leave that Auditor General's report, just wanted to touch on the finding at page 28 of the document, numbered 28 of the document, which is point 1725, 2019 evaluation, last paragraph on the page, of Aboriginal Kinship Finding Program, which DFFH commissioned, found around 56% of Aboriginal and Torres Strait Islander children in out-of-home care in Victoria are placed with a non-Aboriginal and Torres Strait Islander carer. Over 50% are separated from their siblings, and 56% have no cultural support plan. So the issues in the general population are particularly acute within the kinship caring program as well. Would you agree with that? Separation from siblings, lack of care plans, and placement with non-Aboriginal and Torres Strait Islander carers.
Are they an issue? Yes, they are.
Yes, sir.
Yes.
I
want to come to the next topic, if I may, of the
Sorry,
Secretary.
Ms McLeod, can I just ask one quick question about payments? If a child is with a foster carer and they're on, say, a level 5, one of the highest payments, and then they move to a kinship carer, do they remain on that level 5?
Most likely, yes, because that payment level is determined on the needs of that individual child, and usually a child and a carer attracting that level of payment would suggest there is a complexity of need within the child's presentation that warrants that level of allowance.
There has been some evidence given to the Commission that they've had to make business cases to go back up to that level. They've dropped down to a level 1. So I just wanted to clarify what the department's stance is on that, if you can.
Yeah, I'd be surprised if it dropped from a level 5 to a level 1, unless there was an administrative error in the process. Just intuitively thinking about a child who's on that level of care allowance would suggest pretty intense complexity.
Yep, thank you.
Now, I want to come to the topic of the Secretary as parent, if I can call it that, and paragraph 67 of your statement. Paragraph 67 states that under the Children, Youth and Families Act, the Secretary must provide necessary care and support to children and young people living in out-of-home care and act as a good parent would. So that is because the Secretary assumes parental responsibility and the duty of care for a child in their care.
Yes.
Now, concerns about the lack of safety in state care have been well documented over an extensive period, including in the Commission's report, Our Youth, Our Way. You'd be familiar with those concerns, and you'd be familiar with the report that the state does not routinely conduct forward-looking risk assessments when making a decision to place a child in the care of the Secretary. You aware of those specific criticisms in Our Youth, Our Way?
Can you just repeat?
Yep. The state does not routinely conduct thorough forward-looking risk assessments when making a decision to remove a child, which take into account the possibility of a lack of safety in state care.
Yes, I'm happy to accept if that's what's been proposed in one of those reports.
Well, it makes sense, doesn't it, after examination of the risk assessment model, there is no factor that a practitioner has to take into account that tells them, danger alert, if you place this child in the care of the Secretary, there is a risk of a lack of safety, which may include abuse and neglect.
Yes, the only caution I would have to that characterisation is that most children are placed within family settings. The vast majority
Well,
of
within
them.
the care of the Secretary.
Indeed.
So those who are in residential care, away from their families, are primarily that group that is exposed to this risk of lack of safety?
Well,
Not necessarily.
not always.
Okay.
I just want to qualify that there are approximately 450 children at any point in time in residential care services.
Yes.
They are, by their very nature, some of the most complex children who have complex needs because of their trauma histories.
Yes.
It is less than 5% of our total population, an important 5%. However, given the significance of their trauma histories.
Is this cohort managed by a particularly skilled or an experienced team within the department? Or are they spread out across caseworkers?
They are largely, so two aspects to that question. The care provision is provided by a number of funded community service organisations who deliver residential care services.
Yes.
Their case management is undertaken largely by the statutory child protection system, but there is provision where we can contract their case management to some of those care organisations as well.
So it's not necessarily the case that there's this cohort with very complex needs is managed by a experienced caseworker or overseen by an experienced supervisor.
Within the construct of our residential care system, we have a number of models across the residential care system that range from generic care systems to generic care services through to therapeutic care services. So a young person within a therapeutic care service, because of their needs, would receive a range of supports, both from a case management perspective, but also from a care therapeutic perspective.
I see. Findings from Our Youth, Our Way include these. Finding 18, the child protection system does not provide a stable caring home for too many children and young people involved with child protection and youth justice. Finding 19, the child protection system is failing to act as a good parent would for too many Aboriginal children and young people involved with child protection and youth justice. Does the government accept those findings?
Those findings have been accepted, and is why why government has invested pretty significantly to improve the delivery of our residential care services. And what I mean by that is, historically, the residential care service system has been largely designed through models of 4-bed residential care homes in communities.
Yes.
Over the reform period, we have sought to shift that, both in terms of the number of therapeutic interventions that we are able to bring into those care environments, the improvement in the capability of our residential care workforce, including mandatory qualifications for that workforce, and the diversification of our residential care homes. And what I mean by that is we are moving towards a structure that diversifies from just having largely a 4-bed system to one that has both 4-bed, 2-bed and 3-bed systems. And the reason we're doing that is because both the evidence and the experience tells us that putting fewer kids together with complex needs and with therapeutic support delivers better outcomes than having 4 young people together with an array of complexity in a 4-bed stock standard residential care service.
And as I follow what you're saying, the move to 4-bed initially and then the move to lesser beds subsequently is a deliberate decision to move away from an institutionalised model where children receive care en masse, if you like, in an institution.
again, I probably wouldn't characterise the 4-bed in that way.
I meant that as a step along the way.
No, but I would go back in history and say back in the mid-80s is when we moved from larger scale institutional environments, which would have held more than 4 kids together, to largely a 4-bed construct. Now we're moving into a smaller construct beyond that as well, and adding in therapeutic layers of support, which are incredibly important.
And the intention of doing that is so you can have better individualised care for those children.
Indeed, it serves a number of purposes. It delivers much more tailored, individualised care to those individuals. It minimises the impact of children with complexity of need interacting adversely with each other as well. It means that we can focus more attention about care within the home and minimising the frequency of children leaving care and being out in community and potentially coming in contact with the criminal justice system, or where they might be coming into contact with perpetrators of child exploitation.
Yes. Do you agree that the state cannot satisfy itself? It's discharging its obligation to act as a good parent if it's not routinely assessing the safety of placements in a timely manner?
Yes.
And that, as you've said before, and responding to the Auditor General's report, is a work in progress.
Indeed.
Can I come to the topic of criminalisation of First Nations children? It's a well-documented issue of enormous concern that the child protection system feeds a pipeline of Aboriginal children into the criminal justice system. This commission has heard much evidence about the hopelessness of that situation and individuals' pathway through child protection into youth justice, into the adult justice system, and the subsequent trauma upon them of that pipeline. Okay? A report into the Victorian Child Protection Service found that more than one in three sentenced and diverted children had been the subject, that is sentenced and diverted in the criminal justice system, had been the subject of a report to the Victorian Child Protection Service, and that sentenced and diverted children who were the subject of a child protection report were 8 times more likely than the general population to be Aboriginal and Torres Strait Islander children. So I just ask you to accept that. You may know that, you may not be familiar with that, but you would agree with me that it's a particularly big concern for First Peoples children residing, particularly in those in residential care, that they will come into contact with the criminal justice system at some stage in their lives, almost inevitably. You would agree with that?
Well, yes, I would agree with that to the extent that you are talking about children in the residential care system as opposed to children more broadly across the care system.
Yes,
Yep.
yes, with that particular focus.
Yes.
At paragraph 451 of your statement, you note that the proportion of children that the criminal justice system will have subsequent contact with is particularly high for children aged 10 to 14, 67% of First Peoples children and 66% of non-First Peoples children in the case of residential care. So you state that the data demonstrates the increased risk of criminal justice contact for children placed in those settings when compared to home-based settings. So that's the point you've just made.
Yes, that's right.
Yeah. So what is the explanation, if you have one, for the elevated risk of First Peoples children in state care residential facilities?
It's an extension of what I was just talking about in terms of the context of that residential care service structure and the reform that we've been evolving to shift from 4 beds to more therapeutically oriented services so that we can hold young people, we can minimise their exposure to criminal activity and exploitation.
Do you understand that those advocating against raising the age of criminal responsibility are pointing to the offending of children in the protection of the state, particularly in residential care, as an argument for not raising the age of criminal responsibility?
Could you repeat that for me?
So I'll come
again?
at this another way.
Yep.
The state is placing children in residential care knowing the risk factors around lack of safety in residential care and knowing, well, they may not have options, as you've said, but placing them in residential care knowing of those lack of safety concerns.
Yes, the state is placing children who cannot be accommodated in any other form of care
Yes,
in an intensive model of care,
yes,
largely because those young people cannot be supported in a home-based care placement, be it a kinship care or a foster care placement.
Are you aware are you aware of the Sentencing Advisory Council report, Crossover Kids?
Yes, I am.
Yep. And you're aware that that report notes that residential carers are calling the police not because a child's behaviour was severe, but because of its frequency.
I'm aware of that.
So carers are reporting children to police for what might be relatively minor offences that they feel unable to cope with.
Which is why we have put in place an approach that lifts the capability of the workforce, that builds more strength in that workforce, that adds therapeutic practitioners within those models of care to be able to more effectively manage the presentations of some of those young people. It is one critical action that is part of our reducing criminalisation framework that we are engaged in.
So this is not a criticism of you or the department. What I'm getting at is that criminal offending by children in that cohort are used as statistics by those supporting or arguing that the age of criminal responsibility should not be raised to point to the frequency and seriousness of offending by children. So the very conditions that the state creates are used, if you accept my proposition, to argue against raising the age of criminal responsibility.
I'm not sure that I follow.
Okay.
And it might be because it's late in the day, but
That's okay.
I'm not following.
The Sentencing Advisory Council report, Crossover Kids,
Yes.
points to the frequency of reporting and the nature of minor matters reported for children in residential care.
Yes.
Accept that? That leads to inevitable interactions with police.
Yes.
That leads to the exercise of police discretion about whether or not to charge a child with criminal offending,
Yes.
including maybe property damage, things of that nature.
Yes.
That leads children to the criminal justice system as youths who
Yes.
are less than 14 years of age. That leads inevitably, and is one of the components that leads to convictions on charges against children who are within the system. Do you follow?
Yes.
That leads to a data set that is used by those arguing against raising the age of criminal responsibility to say, look, there are all these children offending who are 13 years of age. Do you follow? And yet it is the state that has created the condition of care that leads causatively to those statistics being increased. Do you follow?
I do follow. and it is why the state and the department are working to improve the delivery of our residential care services, informed by the Commission's determinations, findings, and recommendations, and an accepted view globally that having more therapeutic services with a smaller ratio of children to worker with increased capability will reduce some of that offending and interaction with the criminal justice system. I think I said yesterday, not that I want to downplay this in any way, but we have very few children that, I think I mentioned the number of 33 young people through our data linkage work that are current dual ordered children across
Yes.
child protection and youth justice.
Still think the question hasn't been answered. So you're giving a response to what you're doing now, but the question around the data being used to inform the government's decision around raising the age. Can we go back to that original question from Council?
So that's a decision, obviously, that's taken by those who are external to the department and advocating for a particular position. So you can't.
I can't comment about that. I think that's for others to.
But you do acknowledge that there is a contribution that the state plays to those
I
statistics.
acknowledge that, which is again coming back to what we are trying to work on in terms of reducing that contribution, and the work both in terms of our residential care reform and the framework for decriminalisation of children in residential care go very much to focusing our attention on driving those numbers down, even beyond the relatively small numbers that we have across the system at the moment,
The
notwithstanding
recognition that you're going to
importance.
do something about it, which means there's a recognition that it's contributing to it, because you're making a response to it. So
Indeed.
therefore, yeah,
Yeah.
thanks.
Last couple of things, noting the time. Are you familiar with the Maram Nala Gambu program?
I am.
The Commission has heard evidence from magistrates involved in that program about the success of the therapeutic model and culturally
Yes.
appropriate model adopted by that program.
Yes.
Would the department support extension of the pilot program from Broadmeadows and Shepparton of programs that adopt a therapeutic model?
We would support absolutely any extension and further integration of models that bring therapeutic justice approaches to our families across the system.
There are a couple of matters to follow up on from yesterday that I understand you can answer today. The first was a question around recent data on the rates of children in out-of-home care, Aboriginal children in out-of-home care, and Commissioner Lovett asked for data, and you said at transcript 50, it's worth noting the rate of First Peoples children in care peaked in 2020 and 2021 with a rate of 103 per 1,000. In June 2021 has fallen slightly since then to 102.2, and I asked you to follow up and asked you for data about that. Is that a matter you can comment on now? Or is that a matter we need to give you an
Let me just
opportunity to
quickly
come
try
back
and
to?
find.
Oh, no, that's okay. You've probably got a note somewhere.
So just could you repeat which one that was in relation
Yes,
to?
there was a question in relation to data on rates of children in out-of-home care for Aboriginal children compared to non-Aboriginal children. And Commissioner Lovett asked you a question about data and the 3%. Oh, yeah, confusion about the 3% and the yeah, okay. Your evidence was you've seen that reduction come down by 3%.
Yes.
And there was questioning around whether the data had fallen slightly, as noted in your statement.
Yes.
and you were asked to follow up about that. Are you able to do that now?
I'm able to confirm that that decrease did in fact occur.
3%?
3%. As I indicated yesterday, the data was presented to the Aboriginal Children's Forum back in October of last year. And importantly to note that over the last 4 years, there have been increases in the number of Aboriginal children in care of the range between 5 and 15%. So to see a reduction of 3% when we've been on a trajectory of increase, notwithstanding the early promise, is an important pivot point, I think, for where we are today, and we attribute that to a number of family preservation and diversionary programs that we have implemented across the system.
But it's not yet a trend, is it? It's just one one data point. So
but
we would need to see
absolutely, yeah, absolutely, but
reduction this year and the year
absolutely, but
trend.
no, absolutely, but again,
If you need to revisit your statement at paragraph 20, to just check those numbers that you've given us there, you're welcome to do that in the follow-up material. Sorry, 120, okay. The second point was around the names of committees and minutes. I won't ask you to do that now because that's something you can easily provide us. I didn't want to ask any further questions about that. And the third matter that I think you can talk to today is around reunification data and Commissioner Walsh's question of those that are removed, what proportion of First Nations children are reunited in 12 months? And you said you could get that. Do you have those figures now?
Yeah, so as of July 22, those children that were managed by ACAC that were either on a care by secretariat order or a long-term care order, making 52% of ACAC children. And the next largest cohort was on family preservation order, 25%, followed by reunification orders, 22% of children. The data set also indicated that Aboriginal children that exited their latest episode of care between the 1st of January to the 30th of June for ACAC clients was 83%. So that's 29 children that were reunified with their parents and families, relative to 64%, 235 children for child protection clients.
Commissioners, I haven't touched on the question of unborn notifications. I'm just noting the time, so I wanted to pause and check if there are questions on any topic that the Commissioners had before we conclude.
I think I have lots, but I don't think time, and I guess as Commissioners will speak, whether we invite you back for further discussion. And it is a very, it's a topic we need to discuss, the unborn notifications. But I don't think there's not enough time.
I agree.
So there's an indication from the Commissioners that we might like to get you back. And what we will do is negotiate with those assisting you to look for a further provision of information that the Commissioners have asked for, and then find a suitable time to do that.
Certainly.
And given that we're working under time pressures, we would ask that those assisting you attend to the provision of that information as quickly as possible. Yep. Okay. Commissioners, please, that is the evidence of Mr. Alisandratos for the time being, and noting your power to call him back. There is a tender list. 4 of the documents have already been produced. I tender the balance of that tender list document, which run from document 4 down to 113. in accordance with that tender list.
Thank you. I'll be giving the next exhibit numbers. Thank you. Thank you.
Would I be able to make a statement if that's all right? Could I make a statement before we go? It's been a big 2 days, I guess. We didn't cover everything, but I want people to remember that every statistic we spoke about today and yesterday was a child, and I don't want us to ever forget that. On the 13th of February 2008, Prime Minister Kevin Rudd offered a formal apology on behalf of the nation to Australia's Indigenous people, particularly our stolen generations. He said, "We reflect on the past mistreatment. We reflect in particular on the mistreatment of those who were stolen generations, this blemished chapter in our nation's history." It's 15 years on and we are sitting here again. I think this is a new chapter, a shameful chapter. A shameful chapter, as the state has rightly pointed out. It's 15 years on and we're still hearing the same stories of removal of Aboriginal and Torres Strait Islander children from their families, their communities and their country. We've talked about the work of the department has done to give effect to self-determination by transferring powers to Aboriginal orgs, and you have acknowledged many times that there's room for improvement. You've also identified that not all AGOs want to take on the powers and there is a lack of trust that needs to be built. In drawing on all these points together, along with the recurring themes drawn out from the evidence provided to the Commission from community-controlled organisations and individuals, it is clear that there is a need to not only listen to, but implement the change that Aboriginal orgs and individuals are not only making to this Commission, but directly to the department. This requires appropriate funding and support, their legislative reform agendas. That is how you build trust, by acting on and not just listening with ACOs and communities, and making sure that they're now based on their evidence base. Just wanted to.
Thank you, Commissioner
I
Houghton.
just wanted to have a closing remark too. I've been particularly concerned throughout this at the ongoing evidence of the lack of transference oversight of the achievements or lack of achievements of the goals and objectives of the very many reports and strategies that have been written about this area, like the VAF and the Roadmap to Reform. And it worries me that that has led to a lack of accountability, and it even seems to me that the incredible overrepresentation of First Peoples children in the child protection system has become normalised, as if the ongoing failure of departmental legislation, policy and processes to reduce the number of First Peoples children in out-of-home care is not a policy failure, which is, in my view, of truly epic proportions. It's just somehow the way things are, that it's expected. So no heads roll, no one takes responsibility, no one is held accountable. And to me, this is just a tragedy.
One more question. One more question from me. Thank you. We heard from both commissioners just then. And, is there anything that you would like to say to Aboriginal people, their children, their families, whose lives have been made worse by the child protection system? What's your message to them?
I accept the significant level of shame that we have openly acknowledged in terms of our delivery of support to our First Peoples across the state. I accept that we have not provided adequate support and we have failed many, many children and young people. That does not diminish in any way our genuine commitment to continuing to improve and to work tirelessly as we have, engaging deeply with community, engaging deeply with our community-controlled organisations, learning deeply from them and implementing those learnings across our service system. I acknowledge that it is in the construct of an existing legislative framework, and I acknowledge that that has limitations, and that if we are truly to effect significant change beyond what we've been able to effect to date, it's going to require a very bold approach to a future system that is absolutely Aboriginal-led. But in doing so, I caution that that will require careful consideration and planning and support of all of those that will provide that support to families across the state. But it's clearly not good enough, and we clearly need to do more. And I think we are in a unique position here today with the work of this commission, with the work of treaty, that will fundamentally shift the dynamic that has existed across this state. And we should seize that opportunity. And this department in this state is absolutely committed to driving that reform, whatever that looks like, into the future.
Thank you, Chair.
Thank you. Thank you. I don't propose to say anything on this occasion. I did say at the beginning about the concerns about wanting truth from the government, and I think we've heard it today in a way that's so distressing, to be honest, that at this time on a Friday afternoon it's not worth saying anything else. But thank you for your contribution today. Thank you.
You're welcome.
Thank you. Commission adjourned until,
Or Monday? Is it Monday? Yes.
thank you.
Thank you very much.